Lordships kindly. Writ appeal where urgency is this, my lord. The learned single judge has directed the municipality to draw the sewage pipeline system in the private property belong to me, my lord. The municipality contended, my lord, it cannot be directed to encroach upon the private property, against which the writ appeal is filed by the municipality also. I have also filed a writ appeal, my lord, challenging the learned single judge's order. In the meantime, my lord, the Honorable Lokayukta, my lord, summoned the municipality commissioner and my lord, directed him to execute the work within 7 days, my lord. As per the Lokayukta instructions, my lord, they are carrying out the work, my lord. My writ appeal is pending, municipality writ appeal is pending, and my lord, they are carrying on the work, execution work, my lord, day and night, damaging my property. Man. Next week, any day. Man. Urgency is this, man. They are altering the nature of the land completely.
Fresh writ appeal.
Pardon, my lord?
It is a fresh writ appeal.
Fresh writ appeal. Fresh. Office objections are removed. Next week, any day.
7th.
Please, madam.
7th.
Please.
The writ appeal, your lordships had heard it, my lord, and had orally observed that the parties are to maintain their equities, but in violation of your lordship's observation, the respondent 3 has delivered the goods to respondent number 1, my lords. We are hurrying up to complete the order.
Which matter?
My lords, it was a tender matter, my lords. The lordships had heard it and had orally observed. If your lordships would have it next week anytime.
Is pending or reserved?
It's pending, my lords. It's been listed for 14th.
14th.
But my lords, they're wanting to complete the order before the next date.
What do you want? Contempt you want to move?
My lords, my lords, the same writ appeal, if it could be listed next week anytime.
IA. That will not by memo. Once it is posted by judicial order, we file some interim application
Please,
for preponement.
please, my lords. Please.
Yes.
Let's make
serial number 26, my lord. My senior mother death ceremony. That's why week's time.
12th August. 12th August. August 12.
Serial. 26. Serial number 26.
your lordship, serial
Go
number
on time. August 12.
12th August.
Please.
That's one mention, that's serial number 12. That's it is a matter, which my lords may recall. Mr. Sergeant Powai had appeared on the last date, an advocate general had appeared. It is a writ petition, a writ appeal filed against the single judge order, where aggregators have come before having some grievance, my lords. May I request, my lords, to have it next Friday. There's some difficulty with availability of the advocate general. So, my lords, may have it next
What is it
Friday.
about?
My lords, it's a matter. It's a matter.
It relates to, my lord, the Uber, which, my lord, and the aggregators, my lord, when you, my lord, if you want a taxi, we, my lord,
Yes, let's may have it next Friday, my lords. And in the meanwhile,
agency.
my lords, we also have preferred a writ appeal, my lords. It may be tagged along with that.
Who has prepared it?
My lords, the state has preferred a writ appeal, my lords. May next Friday it may be.
Some observations were.
Yes,
my lord,
it is.
Petition Commission, all that, therefore, my lord, it affects us.
My lords, next Friday, my lords, we'll make a submission.
I'll
Some
tell you.
personal difficulty.
To be listed with cross writ appeal number.
962.
What is the number of?
That's the writ appeal number has not been given. It's only a FR number which has been given. Only the filing number. Writ appeal filing number is 1111 of
List appeal
2024.
filing number 1111/2024. Full stop. In this writ appeal, if which objections are subsisting, they shall be removed before the next date by the state.
Grateful, my lords.
To be listed on
That's Friday, my lords.
Second.
Yes.
2nd of August.
Please.
Grateful, my lords.
Your lordship, serial number, sorry. Lordship, serial number 13. I appear for the appellant, your lordship.
Serial number?
Memo for question.
Which serial number?
Writ appeal 303 of 24. Writ appeal 86 of 24. Urgency ಐತೆ ಮಂಟೆಗೆ.
Little louder. Go to the mic and say, what are you telling? What do you want?
Memo for posting. Memo for posting.
It will be posted. What is the difficulty?
Writ appeal 303 of 24. Writ appeal 303 of 24 ಮತ್ತೆ writ appeal 386 of 24.
So you remove the office objection, you post it.
Monday
Remove
29/7.
the office objection.
Office objection complete ಆಗಿದೆ ಸ್ವಾಮಿ.
Then it will be listed. You wait for 2-3 days.
Non-compliance of office objection ಎಲ್ಲ ಕಂಪ್ಲೀಟ್ ಆಗಿದೆ ಸ್ವಾಮಿ.
Then it will be listed within 2-3 days. Wait.
Monday,
If it is
Monday.
not listed, then mention again.
ಅರ್ಜೆನ್ಸಿ ಐತೆ ಸ್ವಾಮಿ ಇದರಲ್ಲಿ.
What is the urgent?
ಇದು ಪ್ರಾಪರ್ ಸ್ವಲ್ಪ ಅರ್ಜೆನ್ಸಿ ಐತೆ ಸ್ವಾಮಿ. ಅದು
12th
ಪ್ರಾಪರ್ಟಿ ಸರ್ವೆ ಮಾಡೋಕೆ ಬರ್ತಾರೆ.
12th August.
Your lordship, serial number 13. I appear for the appellant, your lordship.
13.
1-3, your lordship. 1-3, your lordship. I have informed the creditor respondent also, your lordship. I am led by a senior advocate in this matter. He is not available today. May I request for 6th or 7th of August, your lordship?
19th.
Faithful.
With your lordship's kindly,
Faithful.
the yesterday's matter, pollution control board matters, we assured the court that we are going to file return submissions today. I seek indulgence of this honorable court, Lord, will file it on Monday morning,
But Monday, latest by Monday.
please.
Refreshment.
List two, seal number 1.
I appear for petitioners here, my lordship. I appear for petitioners in this matter. My lordship, we are challenging the admission overseas committee's order, my lordship. And the similar matter is coming on 30th.
So 1 second.
This connected matter is listed on 30th, my lordship. Maybe connected, see,
The other connected is on 30th.
30th, my lordship.
30th. Okay, see.
The content matters, list 1, seal number 1, Mr. Sumant L. Bharadwaj.
Complaint, my lordship. The matter pertains to release the final bill, my lordship. File this contempt petition with prior to that appropriate direction to action against the accused person to release the final bill, my lordship. I have filed the writ petition seeking for writ of mandamus. Thereby directing to release the final bill.
(29/11/2021), my lord. An order was passed directing me to consider the representation. Page 13 is the order. Representation is considered. Respondents BBMP is directed to consider representation dated so and so submitted by the petitioner and release the payment of past appropriate orders in accordance with law. This order, my lord, has already been complied with. My lord, a notice was also issued of the compliance. I have the paper, my lord, since it is in Kannada.
Not done.
Not granted. It has been rejected.
Yes. 19th August.
Please. I am for BBMP, my lord. What has happened here is
Notice already issued.
notice, my lord, notice was issued in this matter. I have already entered appearance in this case.
You are for complainant.
Yes, my lordship.
So it is complied with, that is your counsel.
We
Since
don't-
it is in Kannada, I'll have to give a translated copy. If
We don't have any aware about that, my lordship. We
it was
have
sent
to-
by registered.
We have
post.
to communicate it with the,
Give
Right.
copy to.
Please, I'll do that, my lord. Kindly call this next week. In the meantime, today morning I have received these papers. My lord, I'll furnish a copy to him.
So Tuesday at 2:30.
Please, please. Much.
To be listed at on the first, 31st, 30th. At
Much.
2:30.
Seal number 2,
I'm appealing for the
Sajinath.
complaint in contempt. The order has not been complied, my lord. Your lordship may kindly see page 45, my lord. They're entitled for all the terminal benefits, my lord, on par with the central government, my lord, central government employees.
Notice.
And I would like to reveal that they have also filed writ appeal, my lord. I'll give the numbers of the writ appeal also, my lord.
Alright. For the time being, notice.
Notice may be obliged.
Number 3. Appear for the petition in the first matter.
This matter, my lord. Lordship was pleased to, my lord, to direct the commission to file our reply. Lord, my apologies, my lord, I have not given the English translation, my lord, otherwise I have filed the English translation of 2 letters. My
Then our affidavit is ready, my lords.
Yes, what do you?
My lords, both the affidavit of Commissioner of Police and Commissioner of BBMP, my lords, are directed us to file. State's affidavit is ready, my lords. We'll serve a copy and we'll place it.
lord,
Pertaining to the flexes, illegal flexes and hoardings in the city, my lords. And my lords had last time observed that a draft is already been approved by the state, and BBMP has now published the draft notification of the new rules and called for objection, my lords, for 30 days time is given. My lords may take it up after 30 days, my lords, then we can place on record the final,
What about the hoardings which were placed despite the order dated 24th of
please.
18th of January 20?
That we,
my lord, as against that, my lord, I have filed my report. My lord, the Assistant Commissioner has filed the report, my lord, we have sent.
Where is the report?
I have, last time, no, no. As against my lords, the suo moto proceedings, my lord, I have filed already in the suo moto case, my lord, 19-234. 19-234, which my lord was pleased to initiate suo moto proceedings, my lord. Lord, I'm extremely sorry, my lord. The 2 letters which are in Kannada, my lord, I have not translated, my lord. I'll place it on record. Lord, that incident which my lord had noticed in the papers, my lord, it para 7, my lord, of my.
No, where is your report? See, we have issued notice. Have you seen the order?
Yes, my lord.
No response has to come as far as para 5 is concerned.
5.1 paragraph. In addition to notice in the suo moto proceedings, court is inclined to seek answer from the.
Yes, my lord. That
Why? They should be booked for contempt. So where is your reply to that?
replied only, my lord. I have filed it to reply.
Where is that?
Okay.
And who appears for police commissioner?
my lords, state is appearing.
Where is your reply?
I'm filing it. It's ready.
What you are doing all the years, all the months?
My lords, we have been filing various memos.
Not filing, you permitted the hoardings and flexes to come up despite the order operating the group of.
My lords, it is the BBMP, my lords.
What is your mechanism that to prevent the?
Yes, I'll just place this, my lords, my kindly.
We are taking it very seriously.
Yes, my lord.
There is a blatant disregard of the orders for months together.
My lord, in fact, my lord, action has been taken, my lord. Nearly
What action taken?
Cases have been.
You are taking action only to permit the flexes to come up. No other action are taken.
Sorry, my lord.
Where is your reply? Let us see.
Your lord,
Where is-
para 5, your lordship, para 5 is very clear.
Yes.
Court officer. Court officers.
My lord, I have put the table, my lord, as to how many in each division, my lord, what are the numbers of plates penalty has been imposed, my lord. And thereafter, my lord, plates 3. Each division, my lord. Now, my lord, we have called for tender for appointing private people, my lord, for outsourcing it to remove these tenders. 2 tenders were called, my lord, none of them have came forward. Now, for the 3rd tender, my lord, 1 person has been there. He has come up, my lord, and yes, single tender is there, that we are considering.
There is absolutely silent affidavit to our contempt notice. There is not a single whisper. We'll call him here. Are you ignoring like anything, Mr. the High Court? Not a single line in your affidavit about the why you should not be booked for contempt. Why?
My lord,
Are you ignoring the High Court to such an extent?
sorry, my lord.
Now, where is the,
I'm sorry. May I request, my lord, para 11.
not a single line, Mr. Counsel?
My lord, para 11, my lord, para 11.
What para 11?
Para 11, my lord, I'm sorry, my lord.
It is no answer. We want a detailed answer. Why did you not obey the?
File a better affidavit, my lord. I file a better, my lord, I have no disrespect for this court, my lord. I will definitely, whatever.
There is a total overlooking of the orders of the court.
No, my lord, I will file a better affidavit, my lord. I will file a better affidavit.
What did you prevent? What did you prevent to file?
Take any This one, my lord, that we will
Mr.
definitely.
Counsel, not a single whisper about you, about why you should not book contempt. You never focused, and your affidavit suggests that you never take any preventive measure. There is no mechanism evolved after the order dated 18/1/24. Only punitive measures. Once the flexes come up, you permit them, then remove. We don't know whether remove or not.
What happens, my lord, may I explain, my 2 minutes? What happens, my lord, these advertisements are put up in the.
Then your police commissioner says that if you receive the complaint, we'll take action.
My
As if
lords-
the court orders are of no consequence.
My lords, we have complied. I have produced annexure R.
No answer, that once you receive the complaint, you must monitor the thing.
Please, we are, my lords, we have formed teams all around the city, my lords, have placed on record where the inspectors are being made in charge. My lords, may kindly take my annexure R5 and R4, my lords. The FIRs lodged and the teams which have been constituted by the Commissioner of Police for taking care of the situation. Every zone, my lords, we have made a police inspector and cops in charge. We have made team, my lords, every zone.
You are not stated, where is your reply?
My lords, my affidavit is available.
Okay. What you stated?
My lords, may I just read from para 8, my lords? The last paragraph, page 6. I have explained the various directions issued, and my lords, pursuant to my lords' directions, we have formed various teams.
Again, receive the complaints.
My lords,
So you wait till the complaints are received.
my lords, even, my
Never
lords,
monitor the things pursuant the court's order.
my lords, we
There are
have,
no, court's order are non-existent.
my apologies, my lords, annexure R5, my
Why
lords,
should
may
you wait
kindly
for
see.
contempt? You
My
are
lords-
supposed to monitor the things.
My lords, the police have been really diligent. My lords, may kindly take up our FIRs lodge, my lords, annexure R4. Just in 1 month, my lords, we have lodged more than 230.
Let us see what you have said.
Please,
First is that memo, then instructions are received to the police station to receive complaint.
my lords, para 3, my lords, we have,
Paragraph?
para 3 of my affidavit, my lords. What various,
Paragraph 3 only. We are
please, my
reading.
lords. We have directed all the police stations, my lords, and we have,
Court directed to receive the complaints.
my lords, receive the complaints and give police protection to the BBMP officials to remove them wherever there is an illegal hoarding. The police are there, my lords, to give police protection, make sure that no law and order problem happens in all those places. My lords, may kindly turn to page R4, my lords, the list of FIRs lodged by the police department and the team which we have formed, my lords. We are also creating awareness amongst people by giving various peace committee meetings, my lords, in various areas. We're making sure that such incidents don't reoccur, and we are always, a police inspector is immediately available for giving police protection. There are 5-6 teams, my lords, annexure R5, my lords, may kindly see. Even recently also.
Your Lordship, the law is that Karnataka Open Places Prevention of Dispute Act 1981, which extends to whole municipalities and even in BBMP limits also, which was enacted by the, given the assent by the President on 28th August 1982. And subsequently, the Honor Supreme Court has also in the MC Mehta's case has observed that these advertisement hoardings which all put up, it affects the traffic, vehicle movement users, as your Lordship has observed in the earlier order, basically. So, in spite of this, the menace is taking place, and there is no response as far as para 5 is concerned, your Lordship's order dated 12/7. And in fact, in the affidavit which I filed, your Lordship, on 12/7, the police have issued a circular, your Lordship. 12th July, I filed an affidavit. In that, I enclosed the memo issued by the police officials, which now that is contrary to the paragraph 8 of my BPP which they have submitted, your Lordship. Kindly look into my affidavit, your Lordship, filed on 12th July. And your Lordship order is very clear, 1 lakh is the penalty, that deposit, para 5. It is not reflected in any of the reports submitted by the BBP. In fact, in the judgment referred by me in 1987 Supreme Court, last paragraph direction were also issued by the Honorable Supreme Court. Removal of all the hoardings, public places.
Building.
Real Sanjeev. It's been commissioner advertisement.
Your Lordship had directed, my lord, the commissioner, my lord.
Commissioner to file. Para 5. Para 5.1.
Illegal taxes, then Sure. Since the epidemic reflects that 8,000 even right there, there come up. Right.
Two eight 23, my lords.
केस कर रहा है
One. Extremely sorry, my lord. The commissioner's affidavit should have been, I'm extremely sorry.
Can you be permitted, my lord?
I'm sorry. Lordship kindly. Lordship kindly, on submission in the the affidavit filed by the Commissioner of Police today, Your Lordship. Para 10, Your Lordship, kindly just, because they say that it's a perpetual in nature. The illegal hoardings and flag is perpetual nature, they are saying para 10, Your Lordship. Now, after removing where they are throwing it, because this court was filed by the Commissioner of Police today, Your Lordship. Para 10, page 6, Your Lordship. The law is page 6, para 10. You. And removal of the illegal. Now, several hoardings are put up. where they are storing and how they are doing it, because the law is prevention. Permanent. It's a permanent nature, that's what they're saying. So what steps they take, I don't know, that's why.
If I may be permitted, ma'am. In my petition, 2044 of 22, I've also asked for the tax which is being collected till date, which are pending, my lord. That is also put in the affidavit. that is there to me. Please, my lord, but they have not collected the tax which for the hoardings, my lord.
No tax in like, now it's an advertisement fee, no tax is there under new law, it is a fees,
But till
advertisement
date,
fees.
pending, my lord. Reply is not being filed. ma'am.
She's asking for the tax imposed. That we
Please, ma'am.
relating to the tax.
The arrears of the tax, my lord, which had to be collected.
I didn't mention that.
Please. Please, my lord.
In fact, Upalata is finding is that about 2,000 crore is the loss cost to the exchequer by way of not collecting the, earlier it was a tax, now the High Court has quashed it, it can be called as a fees. Report, I filed a report also, 2,000 crore even.
My lords, the BBMP has now published the draft regulation. 30 days time is given, my lords. 19th they have published. By 18th, I think finalization will happen. Final notification will be issued. Draft has been issued, my lord, calling for objections. Building by law, the hoardings and advertisements, my lords.
Now the objections have been called for 30 days time.
They'll advertise on that.
Now, by virtue of this draft by regulation, every 100 meters, they are permitting hoardings, advertisement, all things, for collection of a fees. And even again, it distracts the traffic. Anyway, 30 days time is given.
By objections are
File
called
application.
for, my lords, they can
Yes.
file their
very-
objections, then it will be finalized.
Earlier 2018, as per the direction of this court, they formulated a bylaw. That has been approved by this court in 2020, 21. And now they are not implementing that. Now again, fresh, it has been now, we are filing our objection for this. And it is very rare. Every corner, every place, the advertisements are permitted now by virtue of this bylaw. It's more causing more. They should have taken permission of this court or brought a notice of the court.
For the policy, my lord.
All private properties have been also permitted to, earlier it was not there. What does murder fees?
He was brought in, my lord, in view of the directions of this honorable court, my lord, a new policy has to be made. The government has. Yes. Not at, only a draft, my lord, they have called for objections, he has also filed his objections.
The draft.
As of now, there is no licenses which are being granted, my lords.
It was not there. I'll place it on record.
May I submit one thing?
Copy of the.
Now,
That is available on, for public, my lords. We have now published it in the public domain for calling upon them for to file objection. Please.
in 5703
Copies in.
on 22/11/2019, this court intended to, because my petition is not only restricted to the BBMP limit, the entire state. There are even the illegal hoardings are there in the entire state also. Now it is, now the directions are issued in the BBMP limit only, madam. So has sought for, even a court has taken to consideration on 22/11/2019. Said we will do subsequently, but nothing has happened subsequently. Yes, replies.
One by 1 week.
Much also.
Copy of the BBM affidavit to be served on.
Give a copy, madam. I have one.
No, no, the affidavit which is being filed today, madam. Okay, the affidavit filed today. Grateful.
ಫೈಲ್ಡ್ ಇನ್ ಕೊಟ್ಟು ಬರ್ಕೊಳ್ಳಿ ಅನ್ಸೋದೆ ಆಮೇಲೆ ಕೊಡ್ತೀನಿ.
Writ appeal matters, this is number 4, Mr. Burra Joshi.
Library lordships. I represent the first respondent, the writ petitioner. May I request not, the matter would be posted on 6th or 8th of August. Some difficulty could. Because it needs to be heard. So 6th or 8th, if you may kindly accommodate me till.
The Karnataka State Tourism Development Corporation has filed this appeal, my lord. Notice has to be taken.
So may I request on 6th or 8th, my lord, subject to the court's votes. We'll address arguments on the main matters.
I'm for respondent 2 and 3, my lord, the state.
I am for appellant. KSTDC. Tourism Development Corporation of State Instrumentality. Yes.
I'm for the state, my lord, the Department of Tourism and the state of Karnataka. That is 2 and 3. 2 and 3, my lord. State of Karnataka by its Secretary, Department of Tourism, and the Director, Department of Tourism.
Sixth or eighth, subject to the boards.
Please.
Yes.
My lord, there is an interim order, sir. There is an interim order, sir. Macho.
Seal number 5.
And for the appellant in this matter, my lord, since 285 days delay is there, only notice may be issued. Yes, sir.
My lord, I take notice for respondents 1 to 6, my lord. One to 6, my lord.
Please, ma'am.
Seal number 6.
Serial number 6 also no delay is there, lords. 45 days delay is there. Lords. This also notice. Macho.
Seal number 7.
I appear for the
Pradeep.
appellant in this case.
Looks time for the respondent.
Not the writ petition was for, originally, my lord, it was, the prayer was, your lordship would get at page 109, my lord. I'm sorry, page 104, prayer in the writ petition, my lord. First respondent, my lord, is the writ petitioner. Quash annexure A. Annexure A, my lord, is a representation which was rejected by the institute for grant of promotion. Now, my lord, annexure double B. Annexure B, my lord, is he participated in the process of appointment to the post of assistant registrar, which was, he participated, but did not get selected. Now, my lord, the second prayer is for that. Please see the third prayer, my lord. Third prayer, double B, is added by way of an amendment, asking for promotion with retrospective effect as security officer or equivalent, and my lord, and the subsequent in a group post, equivalent post, in a group post. He was appointed, my lord, as security supervisor in the year 1997. Now, my lord, the learned single judge in the order, kindly see, my lord, the operative portion of the order, your lordship will get at page yes, my lord. My lord, page 36, para 34, my lord. In this view of the matter, second respondent institute is directed to accord promotion to the petitioner as security superintendent with effect from 18/9/2005
and thereafter grant him further promotion as senior security superintendent from 18/9/2013. Now, my lord, these positions were not available at all.
Let's, they amended, my lords, kindly appreciate this aspect. No, they are available, my lords. I will demonstrate it. Now, my lords may bear with me. They were available. My respectful submissions are something like this. Let's, the C&R rules to them. Lords, kindly appreciate this aspect.
In fact, my lord, C&R rules,
Have been
if I-
amended,
just
my lords,
one, just 1
2013.
minute, my lord, may I just take your lordship through the C&R rules, my lord? Page
Lords, may I
volume
submit,
3.
my lords, I am due to retire, please, my lords, in few months' time. For the past 30 years, my lords, I have been denied promotion. This is the first time, please, my lords, because of this honorable court's order that I have got a promotion. I will demonstrate, please, my lords, any which way I am entitled. Lords, my lord, if the interim order is given, my lords, I'm retiring, please, my lords, in 3-4 months' time. Lords, I will, my lords, great lot of injustice would be caused to me, please, my lords, I will argue the case, please, my lords, in the event.
C&R. Yes,
Lords, but I will, my lords, let there be no interim order, please, my lords. Otherwise, my lords, 3 months' time, I will retire, please, my lords. If interim orders are, my lords are inclined to grant an interim order, I will argue the case, please, my lords, for interim order. Lords, interim order, my lords, he will, everything, my lords, he will. Now, there
My
are
lord,
posts available. Kindly
C&R
appreciate this aspect.
C&R rules.
Lords,
Lord,
if C&R rules is framed, it presupposes.
No,
please, my lords,
I'm
that there
sorry,
will
my
not be
lord.
posts.
That
Now,
is not
kindly
correct. That
appreciate
is not
26
correct,
years,
my lord.
I have not given any promotion. Time bound, please, my lord, they only give me 2 increments. Lords, how can I survive also, please, my lord, when there are posts available? Now, kindly appreciate this aspect. Now, C&R rules would clearly say, lords, every 8 years, please, my lords, if I am entitled, their promotion aspect should be considered. Now, based on that only, please, my lord, the learned single judge have not relied on the correct provisions, please, my lords, and come to the conclusion, please, my lord, that I am entitled for promotion. My lords, preceding, please, C&R rules, please, my lord, there is a notification. Kindly appreciate, my lords, page number 180,
My lord,
179.
Lord, I am ready to argue on merits also, my
I'm
lord. If
also
my
ready
lord
to argue on merits, my
Yes,
lord.
a date
3
can be
months
fixed.
time, 3 months is all I have, my lord, say, the service, my lords, that is ahead of me, I will retire. And my lords, for the, till, my lords, from the date of appointment, my lords, till, my lords, I retire and I will not get a promotion, please, my lords, if an interim order has come to be passed.
Very
Please. Sorry.
Very,
Apply.
in the meantime, my lord, let the direction be stated.
Lords, I
That's
will
fine.
respectfully submit, please, my lords.
No, my lord, nothing will be left if that is to be implemented.
Lords, from the date I was appointed, lords, 26 years down the line, please, I have not been given one single promotion.
That is not correct, my
I
lord.
have not been.
1 minute, 1 minute.
I will demonstrate.
That is not
I
correct,
have,
my lord.
I am not in the habit, please,
Yes,
lords, of
yes.
being
1
in
minute.
submissions before.
Let-
Only
let-
2 occasions, my lords, they have given me, please, my lords, additional income. They have not given, I have not, lords, if I am permitted to retire, from the date, please, my lords, I am appointed 28 years, my lords, I will retire, my lords, without a promotion.
My lord, may I just, that is not correct, my lord.
That is the correct position.
1 minute, may I just point out to my lords? Why are you shouting like this?
No, it
please?
is something.
My lord, kindly see, my lord, page 121, my lord, for a minute. And 130, my lord. Page 121. That is the first promotion, that is the first upgradation that is given because, my lord, there was no promotional post. It was a standalone post. Page 121. Yes, now, my lord, the new C&R rules, which are not applicable to him, on the page 121, my lord, that is the first promotion. After 7 years, evaluation is done and he has been given. Page 130, my lord, that is the second promotion that is given.
No, it is not
1
promotion, my
minute.
lords, it is
May I-
increased,
I have
please,
not
my lords, in my
completed-
salary.
I have not
How
completed
can,
my.
my lords, he submit, my lords, it
1
as a
minute.
promotion?
That
It
is an
my lords,
upgrade.
emoluments are increased, please, my
Sorry,
lords, they
my
can
lord,
submit like this, sir.
Upgradation is given.
Upgradation, no, I'm sorry.
Upgradation is a higher.
I've been promoted.
Lord, this is not the way to shout like this, my
No,
lord.
I'm sorry.
Kindly
please, my
permit
lord.
me, my
I'm
lord.
retiring, please, my lords, in 2-3 months.
He is retiring in February next year, my lord. He is retiring in February next year.
Retiring, please, my lords, in 2-3 months' time, my lords,
No.
without one single, please, my lords. Please, my lords.
I'm retiring. Yes, next year, February, my lord.
May I submit, my lords, two aspects. 2013, please, my lords, the C&R rules came to be amended. Now kindly appreciate what the C&R rules would have said. My lords, C&R rules are amended, please, my lords, to all employees. If C&R rules is applied, amended to all employees, please, my lords, as per the senior, as per the senior, I have to be given promotion as per the C&R rules, my lords. May I submit, my lords? The C&R rules have been amended, my lords. It permits for promotion, please, my lords. It has been considered, please, my lords. I will demonstrate it, please, my lords, in 2 minutes. My lords may kindly bear with me, please, my lords. I will demonstrate it. Lords, can I request, my lords, on 2:30, please, my lords, on that day? My lords, otherwise,
By
if it-
8?
some urgency, please, my lords, in this. My only prayer, please. At 2:30 minutes, he will retire, please, my lords, without a promotion, my lords. All his life he will retire, my lords. My only submission, my only, my lords, my only endeavor, please, my lords, is to ensure. My lords.
Number 8, the TP Muttan.
I appear for the appellant, my lord. In this regard, my lord, that the respondent was working as a branch manager of the bank, my lord, during the year 2003 to 2005. And during that period, he sanctioned 236 tractor loan with all irregularities. Normally, as per the procedure, he has to, before sanctioning loan, he has to take the legal opinion from the panel advocate. Here, that manager has permitted him to use the legal opinion from the dealer of the vehicle. And my lord, then after that, when the bank came to know that there are several irregularities, they instructed him to stop granting tractor loan. After giving the instruction also, he sanctioned 85 tractor loan. And disciplinary action was initiated against him, and he was found guilty, and he was imposed with the punishment of dismissal, my lord. And he preferred the appeal. Appeal was also rejected. And the review petition, it was also rejected. And the entire terminal benefits in that 2007 one, it was paid. And at the time of dismissal, the last cost to the bank was estimated 9.28 crores. Then, my lord, he filed the writ petition before the Honorable High Court, my lord. The Honorable High Court, agreeing with the findings of the inquiry officer, agreeing with the procedure followed by the bank to conduct the inquiry, only on the humanitarian ground, my lord, the lordship said, no, that because that punishment is very disproportionate, and they reduce the punishment to compulsory retirement. Against this order, my lord, this writ petition has filed. The apex court in 3 cases has held, my lord, that when the punishment is imposed by compulsory retirement and the appeal is rejected and the review petition rejected, normally court should not interfere with the punishment imposed by the disciplinary authority. 2007, it was 9.28 crores. Now, my lord, it has come to 56 crores. Even now, some accounts are NPA. And in many accounts, he has not taken the collateral, and it was treating this as a no loss account and all, my lord, it was the bank has waived. Page number 30, my lord, that orders of the learned single judge. My lord. Charges are page number 57, my lord. 57, 57. There are 5 days delay, my lord. 5 days delay in filing this appeal, my lord. 5 days. But interim order is mandate.
Number 9, to Mahesh Chandra B.
And for the appellant, my lords. Lords, there is a delay of 41 days. Okay, date may kindly be fixed, my lords. Date may kindly be fixed, my lords. Great.
Number 10, Mr. Satish K. My lord, I appear for the appellant and the connected appeal.
For the petitioners in the contempt petition.
The
Lord, in
matter,
both the appeals, my lord, I had filed caveat, but caveats are not put up. For I may permitted to take notice for, my lord, private respondents 1 to 11 in the writ appeals. Also, my lord, there is a delay of, my lord, 295 days, my lord, I will like, please there. My lord, I will file objections to the application for delay also. Please.
may I make one submission, Lord. Matter pertaining to regularization, Lord, the single judge has directed to regularize their service on completion of 10 years, Lord. The state is also agreed by the order of not single judge. Lord, there was in an earlier round of litigation, my lord, an endorsement was issued rejecting the request of the private respondents for regularization, Lord, which is set at naught by this honorable court, my lord. Contempt is also not initiated by the private respondent. If my learned friend could take an undertaking that, Lord, they will not.
Lord, the institution, my lord, cannot have any grievance because till, my lord, contempt petition is filed in the writ petition also, my lord, they all along supported the, my lord, employees. My lord, their cases, we have been recruited, my lord, to their regular post.
Stay off, my lord. My learned friend is there, my lord.
Lord, anyway, my lord, it's also.
Parte
my
cannot
lord,
be granted.
My lord, it's clubbed with the contempt is, my lord, clubbed with the writ appeal matters, my lord. Maybe. It is also clubbed, my lord.
My lord, even my appeal, state appeal has been clubbed, my lord.
Lord,
State's
two
appeal,
writ appeals and
institutions
contempt
appeal.
petition is clubbed together, my lord. There is no apprehension of, my lord.
So what is the date given? The date?
Yeah.
Then the date what?
22nd.
22nd.
Please.
Date.
August. This is number 11.
Published.
Adinaranappa.
Challenge ex parte are passed against this appellant in the single J.
which I have produced it. Appellant being a highest bidder in the tender called by the third respondent. In accordance with law, the third respondent executed a lease deed in respect of pay and use bathroom.
There could be accept notice for all.
Page number 16, the ex parte, third, 27 to R3 placed ex parte. To establish my right in respect of the appeal, I have produced the, filed a IA, producing the document to show that I am entitled to continue in the premises which had given to me, being a highest bidder in the tender, which was called by the third respondent under the Transparency of Public Procurement Act. The third respondent was called for notification, tender notification, and I am participated in the tender proceedings. Being a highest bidder, the third respondent executed the lease agreement for 15 years. Now I am discharging my duties as per the terms and conditions made there. In the, before the single judge, I was placed ex parte, basing on the orders passed by the single bench. The claim made by the first respondent is without any tender.
I am being thrown out on the basis of this order. Being in a highest bidder, as per the law, I have participated in the tender and being in a highest bidder, I was put in possession of the property by executing receiving the deposit and also executed the agreement to me for 15 years. Before the single judge, I was placed expert. I could not able to participate and to establish my right. Wherefore, needs to be stay the orders of the single. I am for the appellant. In the original process, third respondent. I am a three, respondent number 3.
Twelve, 13 are urgent. Number 14. Ashok.
One submission. This case, my lord, my appeal memo, my lord, one page is missing, the ground surgery by mistake. I will get it corrected, my lord. Next week, my lord. Connected matters already been, notice has been issued.
So, but in compliance in contempt matters, number 15.
Right, in this
Uh,
case, my lord,
RP Somchakraya.
but I have included administrator, my lord, since the administrator has taken charge, my lord, he has included as a formal party, my lord, since he has to implement the orders, my lord, administrator, because government has appointed administrator to look after the affairs of the bank, my lord. He is made as a party, my lord, for implementation of the orders. Recovery petitioners are depositors, complaints are depositors before the bank, my lord. Since they have failed to pay, we have approached the consumer forum, my lord. Consumer forum passed the order. Thereafter, we have filed execution petition. In the execution petition, my lord, the Honorable Court has directed the Deputy Commissioner and the Tahsildar to recover the amount under the Land Revenue Act, my lord. Thereafter, my lord, Deputy Commissioner has addressed a letter to the Tahsildar to take necessary steps for recovery of steps. In this regard, my lord, I have approached the Assam Court, my lord. This the respondent submitted that the whole process will be completed within a period of 3 months, my lord. As per order under Annexure B to the writ petition, my lord. Please, my lord. Not grievance, contempt petition, my lord. This is contempt petition. Yes, my lord. Well, at annexure, ink page number 21, my lord. Now the failure submit that you would instruct the client to accompany the revenue certificate, revenue recovery within a period of 3 months. This is fair submission assurance to the citizens. This is the order, my petitioners are all senior citizens, my lord. Since their amount was deposited in the bank, my lord, was not given, taken place, my lord. We have approached the district consumer forum, my lord. District consumer forum passed an order, my lord. Thereafter, we have initiated in recovery proceedings, and your lordship can turn to annexure. Yeah, my lord, recovery certificate was also prepared and forwarded to the Tahsildar to take appropriate steps, my lord. Annexure in page number 15, my lord, translated copy. To recover the consumer deposit amount as land revenue from Lakshmi Credit Cooperative Society Limited, the case number, execution petition number so and so, certificate of non-satisfaction of decree dated 28/7/2020 before.
Matter they have filed complaints affidavit. Affidavit on 17th August 2023.
I will look into it and make my submission, my lord.
Yes. It is clearly stated in the affidavit that not the recovery certificate has been issued and forwarded to the Tahsildar. The last may kindly, para 7, 8 and 9 is relevant.
I have produced annexure. A is the recovery certificate, which was forwarded to the Tahsildar, my lord. Tahsildar in turn, he has to take steps, my lord. We have submitted representation after this to the Tahsildar and also to the Deputy Commissioner. Now, according to my instructions, my lord, the property of the bank has been sold and the amount is lying with the
Annexure R4, page number 20 is the recovery certificate issued by the Deputy Commissioner in pursuance of the order. Page number 22 is the translation. May I read para 5, para 5, 6. Para 5 appears, correct? Para 5 of the affidavit. I respectfully submit that the accused number 1, Deputy Commissioner Davangere has issued recovery certificate dated 4/9/2020 with respect to the above mentioned property. Copy of the recovery certificate issued by the Deputy Commissioner dated 4/9/2020 is produced herewith and marked as annexure R4. The Tahsildar Davangere, based on the recovery certificate, has issued notice on 18/6/2021 to the defaulter, one SR Hegde so to pay the amount in pursuance of the order passed by the Honorable Court in WP number 7392 of 21. Copy of the notice dated 18/6/2020 is here with produced and marked as annexure R5. Second notice also came to be issued on 31/1/22. Copy of the second notice dated 31/1/22 is produced and marked as annexure R6. I respectfully submit that on 25/6/2021, the Secretary of the said cooperative society has replied to the said notice stating that the authorities are to refrain from taking action on their personal property. Copy of the reply dated 25/6/21 is produced as annexure R7. I respectfully submit that since the matter pertains to default of deposits made by the depositors and the same falls under the purview of KPIDFE Act, a competent authority under the KPIDFE Act was appointed under section 5(1) of the 5(1) with a government notification dated 16/5/2020 bearing number so and so. A copy of the said notification dated 16/5/2020 is produced herewith as annexure R8. The said competent authority has received applications of all the depositors relating to Lakshmi Cooperative Society Limited, Davangere. A notification dated 11/3/2022 has been issued under section 3 of KPIDFE Act to attach the confiscated assets and bank accounts belongs to the said society. The copy of the notification dated 11/3/2022 is produced herewith and marked as annexure R9. I respectfully submit that at this juncture, the society has filed a writ petition number 121 of 21 challenging the appointment of competent authority under KPIDFE Act. This Honorable Court on 6/3/2021 has passed an interim order of stay not to precipitate the matter. Another writ petition was filed by the complainant in WP number 10141 of 20, challenging the appointment of the administrator to the society. The Honorable Court in WP number has passed an interim order on 6/3/2021 to not to precipitate the matter. Both the writ petitions are clubbed. This Honorable Court on 5/3/2022 has further passed an interim order not to precipitate the matter. Both above writ petition copies of the interim order passed by the Honorable Court in WP number so and so is herewith produced as annexures 10, 11, and 12. I respectfully submit that before the receipt of the recovery proceedings from the District Consumer Forum, Davangere, the property mentioned in para 4 was already mortgaged in favor of DCC Bank Davangere on 27/3/2018 itself. The copy of the said deposit deed and EACR here with produced as annexure R13 and R14. And this fact is already informed to the President of District Consumer for Redressal Commission, Davangere, with a letter dated so and so. Lord, since there are interim orders passed in the collateral proceedings, Lord, our hands are tied to recover the amount from the deposit. And the complainant is one of the party in the writ petition also. Where interim order has been granted.
We have not received any notice. We are not, none of the complaints were made party.
The writ petitions by my lord, the bank. ಇದು ಡೈರೆಕ್ಟರ್ಸ್ ಅಲ್ವಾ? ಎರಡು ಡೈರೆಕ್ಟರ್. ಎರಡು ಡೈರೆಕ್ಟರ್. ನೋಡಿ Right. I stand corrected, my lord. It is by the director, one of the director of the company. They have filed the writ petition. Director.
Number 16, Mr. Prakash BS.
In this matter also, my lord, we have filed compliance affidavit.
My lord, I am for the complaint. My respectful submission would be, the reply what they have filed, my lord, is nothing short of aggravated form of contempt, my lord. They have totally willfully disobeyed the explicit directions issued by the writ court, my lord.
Last three of the directions, my lord.
At page number 2 of their reply, my lord.
Directions are at page 20. Page 20, class 3 is relevant. An appropriate decision shall be taken by the licensing authority on the basis of Annexure D, that is the earlier notification, as expeditiously as possible, and in any event within a period of 2 months. In pursuance of the same law, we have filed the compliance affidavit. The earlier inspection was conducted in the year 2016. Recently, we have conducted an inspection as directed by the licensing authority on 21/10/2022. It was noticed that, Lord, the very land has been granted to some other person. Therefore, question of declaring that particular land as safer zone does not arise. And we have issued an endorsement to the complainant stating that rejecting his application for crusher. Joint inspection was conducted on 27/10/2022. And a report is, joint inspection and report is produced at annexure R2 and R3. Yes. R2 page number 15, Lord. R3 page number 16, spot inspection by Ravi. Thereafter, Lord, annexure R4 and 5 is the rejection in Form D and the proceedings of the licensing authority. Annexure R4 is the proceeding dated 28/10/2022. Page 27, please. And page number 30, annexure R5, Form D. Refusal letter for stone crusher license. We have decided, Lord, as per annexure D. Appropriate decision has been taken by the authority.
May I make a submission, my lord? May I make a submission, my lord? My lord, the issue is this, my lord. Kindly say, my lord, the order of this honorable court, my lord. The impugned endorsement dated 31/3/2018, earlier endorsement which is assured, not with this reason, it was for totally different reason. Issued by say as per studies cost. we direct the licensing authority to consider issue of declaration of safer zone on the basis of joint inspection at Annexure D, my lord. That is the Annexure D, it was a joint inspection report carried out, my lord. On that basis, they ought to have considered my application and decided the issue, my lord. It was not open for the authority to make a fresh inspection. This is the explicit direction of this honorable court, my lord. So therefore, my respectful submission would be, it's an aggravated form of contempt, my lord. Please, my lord. They have not followed the direction of this court, my lord, explicit direction. They ought to have done the, issued the certificate in compliance with the report that was already given, which was produced at Annexure D in the writ petition, my lord. That is a clear direction. So therefore, it was not open for the licensing authority to have conducted a fresh inspection. It is certainly, my lord, for extraneous reasons it has been done, my lord. They have not carried out the order of this court in letter and spirit, my lord. Nowhere the court said that they should do one more inspection, my lord. They may have rejected, I don't say, but it has to be on the basis of inspection which was already done, my lord. Earlier, an endorsement was issued rejecting the application which was challenged before this honorable court, writ court, my lord. The division bench of this court set aside the order of rejection and gave specific directions, my lord. In the 2018 rejection, this reason was not given, my lord.
Yes, ma'am. Para 20, page 20, ma'am. Page 20. Yeah. Endorsement was quashed, my lord. We direct licensing authority to consider the issue of declaration of safer zone. Was the direction, my lord. We have considered the issue in the light of Annexure D. Annexure D was the earlier safer zone notification issued in the year 2016. Now we have to see the present status of the land.
But that is not the order of this honorable
In
court, my
between
lord.
2006 and the date of inspection, Paragraph 5 and 6 of the affidavit, it is clearly stated. Affidavit, complaints affidavit. I may be permitted to read. It will clarify that. Page 4, para 5. I respectfully submit that the complainant submitted a copy of the aforesaid order, so and so, so and so. I have taken charge of Deputy Commissioner on such and such day. The order passed by this honorable court was brought to the notice of the licensing authority. Further, the application of the complainant dated 3/7/2015 and the earlier inspection dated 11/11/2016 was placed before the licensing authority on 21/10/2022. The licensing authority decided to conduct fresh inspection to verify the present status of the applied land. Since the earlier joint inspection was of the year 2016 and further directed the Department of Mines and Geology, Revenue, Forest and Karnataka State Pollution Control Board to submit the report to the licensing authority. The copy of the said decision of licensing authority dated 21/10/2022 is herewith produced as annexure R1. I respectfully submit that in pursuance of the decision dated 21/10/2022, the licensing authority, the senior geologist, Mines and Geology Department addressed a letter to the concerned member of the licensing authority, informing about the conduction of fresh joint inspection as per Section 1, 2, 3 of Section 6 of the Crushers Act 2011. The joint inspection was conducted on 27/10/2022 and further Assistant Commissioner and the Tahsildar reported that the applied area in survey number 11 overlaps with the land granted to Sri T. Anand so and so with a order dated 8/2/2018 and the said grantees are in possession of the land and cultivating the same. On the basis of the joint inspection dated 27/10/2022, it was recommended to conclude as follows. As the proposed land is already granted, the question of declaring of safer zone does not arise. The copies of the joint inspection dated 27/10/2022
My lord, in the 2016 inspection, my lord, they did not find anybody in possession of the piece of land, my lord, which is the subject matter of safer zone. My lord. In the 2016 inspection, but 2018, they issued an endorsement stating that as per the paper report, since there are a number of crusher industries, permission cannot be granted. That was challenged before the writ court, my lord. The writ court allowed the writ petition and set aside the order, set aside quash the order, but directing specifically to consider the application of the petitioner in relation to the joint inspection carried out on 26/6/2015-16, my lord. That was placed at Annexure D, my lord. So my respectful submission would be, of course, I leave it to the court to decide, my lord. Respectful submission would be, this is only an aggravated form of it because it was not open for them to have conducted one more inspection by giving some other reason, my lord. Till 2018, no person was in picture, my lord. Nowhere it is stated somebody is in occupation of that particular piece of land, my lord. Suddenly, this has cropped up in the year 2022, my lord, when the order of this honorable court was given to them, my lord. And it is also in a preliminary stage, my lord. Declaration of a safer zone does not take away anybody's right, my lord. I can understand when once they grant the license, somebody's right will be affected, my lord. At that time, they could have considered all these issues, my lord. They have exceeded their jurisdiction is what is my submission, my lord. My lord, if my lords decided, I may be permitted. I may be permitted to challenge the endorsement what I issued. I'm grateful.
Obliged.
Number 17, Mr. Raghavendra G. Gayatri.
I'm querying for the accused number 1, the DPC is scheduled on 30th, my lord, and seeks for a week's accommodation in this case.
Yes, for consideration of promotion.
We have published the provisional seniority list, final seniority list. It is pending before the DPC. It is scheduled on 30th. I pray for a week's accommodation in this case, my lord. Yes, my lord, his name is there.
I am at serial number 1 in final seniority. No,
Yes, my lord.
they're yet to consider it. Let the DPC happen. If they're considering it, then I will, the contempt may be closed on next date. Let them.
Yes, my lord.
30th, previously it was scheduled. Again, it is
They
urgent.
have to take the decision, my lord, to promote him or not. That's the only decision they have to take. Yes, my lord. In the list, his name is there. Yes, my lord.
Lords, let them consider, then I will only withdraw it. On 30th, it is there. Lords may post it in first week of August.
Grateful.
Deeply obliged.
Grateful.
Deeply obliged.
Number 18.
In
Shant
this
Kumar
matter,
KC.
compliance affidavit has been filed, my lords, in this matter.
Number 18, Mr. Shant Kumar KC.
The order passed was to do the Durasti and Podi and Durasti, my lords, which has been done. It has been done, my lords. May I point out from the compliance affidavit, page 5.
Invited attention of the court to the compliance affidavit to submit that the directions are complied with and the 4D and Durast has been
Afresh.
conducted. However, since learned advocate for the complainant is not present, put up the contempt petition on Tuesday. That is 30th. Seven. At 2:30.
Hearing on application, cell number 19.
Lots this.
Recalling Mr. Om
This
Paresh.
application has been filed by the state, my lords, recalling the order. The order, my lords, was passed to implement the order passed by the learned single judge. Lords, by the time the contempt petition was dropped, a writ appeal was already filed, my lords, which was writ appeal number 990 of 2024. Lords, that was not brought to the notice of this honorable court, my lords, due to lack of instructions. My only prayer is this contempt petition could be heard along with the writ appeal, my lords. For that, I've filed the application for recalling.
No, 1 second. What is this order?
The order, my lord, this order is passed.
Order is, so
2 months' time is being granted, which the learned single judge has not granted the time for complying the orders of this honorable court.
contempt petition dismissed, cost of 25,000, 15 days. Proceeding. What are the directions in the contempt here?
My
Lords,
lord,
may I-
two for the being aggrieved by the order passed by this honorable court in by learned single judge in WP number 21514 of 2016.
Where is that?
That
Oh.
is annexure
21514.
21514 of 2016. This honorable court was pleased to observe that time was not being granted to comply the order within a stipulated period of time. That has been considered by this honorable court by granting 2 months' time has been granted to comply the directions of this learned single judge, my lord. In pursuant to that, they have filed a writ appeal, my lord, after the lapse of 1.5 years, my lord.
My lords, may I read the order, my lords, passed by this honorable court while dropping the contempt petition, my lords?
Yes.
Paragraph 4, my lords. It says that, however, the directions of the court cannot be allowed to go uncomplied. Therefore, it is,
Where you are reading?
lords, may I? This is the very order passed in this contempt petition. ma'am.
Within 2 months.
Please, my lords. By then, the writ appeal had already been filed, my lords, which was not brought to the notice of this honorable court, my lords. Therefore, my only prayer for recalling the order is to hear this contempt petition along with it.
This for recalling.
Lords, state has filed an IA for recalling the order dated 22nd June 2024.
Recalling. That's all. The order which is brought under the contempt. No, this IA is.
IA is filed by the
This
state.
is. And you have filed again contempt petition?
My lord,
You have filed a contempt.
yeah, I have filed a contempt petition for
Once again.
implementing the order of WP number, order passed in WP number 21514 of 2016, my lord.
In that you have filed IA.
Please, my lord. State has filed an
Should
IA.
have filed independent IA. In this rather than in this. In his subsequent contempt you filed IA?
No, my lords.
No. In this very
Very
dispose of contempt.
disposed of.
Where is
matter.
that put? On board it is reflected. 523, yes, it is here. So still number 19, IA number 2 of 24. This interim application is filed seeking to recall order dated 22nd June 24 passed in the contempt petition, whereby the following direction, whereby it was directed to the respondents to comply with the order brought under contempt within 2 months from the date of passing of the said order. To further observe that the respondents will be exposed to contempt jurisdiction if fails to comply within the stipulated time. Full stop. The ground urged in this application for recalling of the order is that at the time when the order was passed, the writ appeal was already pending, having been filed by the respondents against the said order dated, against the order which was complained of by filing contempt petition. Complained of for its breach for filing petition. Full stop. In that view, when the respondents had filed appeal, and the said fact was not brought to the notice of the court, the prayer for recalling deserves to be granted. Full stop. Had the said aspect of the filing of the writ appeal was known to the court, the order would not have been passed. Accordingly, the interim obligation is allowed. Order dated 22nd June 24. Passed in contempt petition number 523/24. Is recalled.
Please.
Is recalled. Full stop. The writ petition shall be listed on board on. Is recalled. Full stop. However, the compliance of the directions of the order shall be subject to the final outcome of the writ appeal. Recalled. Recalled. Full stop. Recalled. Now, what about your contempt petition?
My lord, the learned single judge has passed a detailed order, my lord.
Same, Shenappa.
Please say, my lord. And the
Which state?
let the connected with the writ appeal, my lord.
Contempt proceedings shall be
Con-
listed along
Please.
with the writ appeal.
Please.
Please, my lord.
Barabar. When it is coming up?
Lords, we have already filed, my lords, no, any date may be.
There are so many office objections also there, my
Writ
lord.
appeal number?
Lords, 990 of 2024.
Writ appeal 9090 of 2024.
9.
Full stop. The same shall be listed after 3 weeks, within which time the state's respondent appellant shall remove the office objects.
Number 20. The TP Vivekanand. Point number 2.
Appearing for the state, my lord.
And the application for early hearing was filed, my lord, and date may be fixed, my lord, for hearing. So I represent respondent number 2. Filed an application for early hearing, but a date be fixed, my lord, so that on that time it could be heard. The matter is admitted, it's on final hearing. I filed an application for early hearing that could be considered.
Ashok, may I list?
It's on board, what is the prayer? It is on board, argue. Early, what is to be early, heard early? Writ appeal or writ petition?
Writ appeal.
appeal.
Writ appeal.
It is on board today.
Please.
Argue.
But senior is.
Senior is not.
On Monday.
All right. At the request of learned advocate for the appellant, stand over to. Respondents stand over to 29th of August.
Please.
Please.
This. Number 21. Vaishali again.
For the appellant.
Lords.
This is that Rajiv Gandhi.
Yes.
Puri, let us complete it today.
Lords, there's a demise in family of Advocate General who's requested for Monday.
Again, just give the broad outline.
My lord, there's a bereavement in the family of the learned advocate general.
Family, somebody has passed away.
Oh,
Requested for Monday, 2:30.
Monday.
2:30, please. Because Monday morning I have some difficulty. I have
Monday
waited. Let's, can I just pass on the synopsis which we have?
Monday. No difference, Monday.
I can, may I just file the synopsis of the list of authorities?
Okay, court, Sam.
The synopsis is ready with the list of authorities. Can we just pass on?
It's a synopsis. Oh. ಎರಡು ಅವ್ರಿಗೆ ಕೊಟ್ಟಿರ್ತಾರೆ.
We have given the list of authorities also.
Non-filing in contempt matters, still number 22. LB Mukanappa.
State has filed the compliance affidavit, my lord, so far as directions issued against the state.
Where are the directions?
Lord's directions are at page 30, my lords, of the contempt petition. Paragraph number 5 and 6, my lords.
13. Yes.
Please, page 30, my lords. 5, 6 and 7.
13 is different. Oh, page 31, yes. Department is directed to initiate proceedings, same?
Lords, respondent number 4 is directed to draw salary
Where
of
is
the
that?
petition.
Para number 5,
Page 30 of the contempt petition.
contempt petition, sir. Page number 30.
Contempt, it is contempt.
The annexure B, my lord,
Respondent 4 is directed to reinstate
reinstate.
the petitioner forthwith. So reinstated,
Reinstate, already it is reinstate, my lord.
reinstated.
Reinstate.
So only question of
Arrears
payment
of
of salary.
salary, but only for arrears of salary, my lord.
Respondent 4 is a private institution, my lords, aided institution.
Reinstated in 5/12/2023, my lord.
So what salary is not paid? Post is paid?
Cost is not filed, my lord.
Respondent number 4 is a private aided institution, my lords. The directions against state is at paragraph number 7.
Of compliance. 7 we have seen.
Please, my lords, we had to take action in accordance with law as per the act. Before we have issued notices and recommendation for withdrawal of grant and withdrawal of recognition, my lords, which we have produced.
So that not a part. Is the management. Number 4 is represented.
That's represented, my lords, but today is not.
Who is for number 4?
Srinath P for
We will wait for number 4. Otherwise, they will initiate the action. That is the only thing.
Please, my lord, salary has to be paid.
Let us wait. To be listed at 2:30 on 38.
Number 23.
Hearing for the
Yes,
accused.
Ramamurthy.
Pay for 2 weeks time to file complaint
weeks.
capital.
Only 30th August.
Please.
For the complainant, my lord. I am for the complainant, my lord.
Complainant. So what is the direction? Let us.
This is, there is a mandamus, my
Execute a
lord.
sale
issue.
deed, my lords. I had to execute a sale deed in favor of the petitioner within a period of 8 weeks. I shall comply with the direction. and shall
Page
file the-
18, my lord. Of the order.
Sale deed.
There is a mandamus.
So you do within that time.
Lords, I was told, my lords, the authorities having a discussion regarding filing of a review petition. Lords, I'll make my submissions on instructions, my lords. Kindly
We
grant
keep
2
it
weeks.
earlier. File day for decision. It was stated by Lorna Dev, the respondent, that the authorities are contemplating to file a review petition. Be that it may. Full stop. The directions have to be complied with unless the appropriate decision oblique order is. Appropriate decision oblique order is taken, or order is obtained from the higher. Oh, the order brought under contempt is of March 2023. In order to enable learned derogatory respondent to take instructions and to apprise of the court about the development at the end of the authorities turned over to 7th August. Let us see what 7th August.
7, my lord. What is the order, my lord?
Order is he wants to take instructions about filing of review petition. We are granting time up to 7th August. Then we'll do whatever we want to do.
Yes.
Number 24. So Mahesh, shall go.
Respond of Ayulas.
But I appear for the petitioner in this case.
I filed wakalat. Permitted to file my counter malad to be.
Not filed.
Yesterday only I filed wakalat. Yesterday only I filed wakalat. On
Learned
behalf of
advocate
respondent.
Mr. So-and-so, 6 time to file the counter affidavit, turned over to 16th is holiday, 21st of August.
I'm grateful. My lord, my learned friend appears for the fifth respondent, my lord. The state may also be directed to to state its position.
So who is to comply? Who is the complying authority?
State.
Well, the complying authority respondents 1
No
to 4.
state at all. 1 to 3 I undertake.
Very well. The order is supposed to be complied with by respondents 1, 2, and 3, my lord. So are
What
all
is the order, page 75,
71.
75.
Please.
Appropriate action under section 248(3) of the Act. It is regarding pending appeal.
Appeal, your lordship. Appeal, my lord, now that was pending, your lordship. It was reserved for orders, my lord. I don't know whether the order has been passed or not. my lord.
File your reply.
I will file my reply. Grateful.
Obliged.
25. The Shanti Bhushan.
For the complaint. The order is at page 15. To direction to return, the bank to return the amount of rupees 20 lakhs to the petitioner within 4 weeks.
Again, the order, my lords, writ appeal is filed, my lords. It is coming up on 20th of August. Notice is ordered by me.
20 lakhs to be returned to be subject to the proceedings initiated by the borrower?
Because they filed, there's a civil suit pending before the civil court.
Writ appeal is filed, my lords, against the
By-
order. By the accused, my lords. It is
Against this
coming,
or-
please, again, the same order. 20th it is.
It was stated by learned advocate Mr. So and so that the accused, that the respondent has filed writ appeal number 843 of 2024 in respect of the order which is subject matter of the present contempt petition. And that the next date in the said writ appeal is 20th, 208/24. In that view, the present proceedings shall be listed along with the
Grateful.
appeal proceedings, petition proceedings, with the petition on 20th,
Great.
208.
Yes. 26 urgent, seal number 27, Mr. Mahendra Kumar Mitra, party in person.
26, I appear for respondent 7 and 8.
Time.
It has been adjourned, my lords, 26. They have not informed me, but there is an urgency in the matter. One date may be fixed.
Which is it? Which is?
26 adjourned.
26. It is urgent.
They mentioned it. And
It is about what?
my lords, it is a PIL which is maintained wherein I am, my lords, a lessee. I have obtained quarry license and I am unable to operate for the past 6 years, though the land which I am in has already been worked by 12 other people. Now the petitioners are claiming that their agriculture is there and there is going to be depreciation of their agricultural products, etc., which is not the case. And FIR is registered against them being
Who
false
prayed?
grant.
Who prayed for time?
They might have probably taken.
Petitioner prayed time in the morning sessions. It is
But
written
this
as
is-
12/8,
It is 26.
26.
26.
26. Like one.
12/8, please. It may be had on 12/8, please.
Come on 12th of August.
Please.
12th rakha hai. It is kept on 12th.
Item 27. Mr. Mahendra Kumar Mitra, party in person.
Hear him to respond in 6 and 7.
For the respondent 1 to 4.
Respondent number 8, madam. Okay, not it.
Nakidiva. You appear for municipal commission. Who is it? No, no. Who is it? ನಾವು ಇದಕ್ಕೆ ಅಪೇರ್ ಆಗಲ್ಲ 4 ಅಪೇರ್ ಆಗಲ್ಲ Covered by the legend or ಗೊತ್ತಲ್ಲ, ಈ ಇಶ್ಯೂ ಮೇಲೆ ಒಂದು ಆರ್ಡರ್ ಇದೆ ಆಗ್ಲೇ ಒಂದು ಸೆಟ್. Started.
What is your prayer? Yes, what is?
Sir,
Who is
my-
appearing?
My lords, my prayer is that
Who is appearing amongst three of you?
I'm happy.
Take yours.
My lords, on 14th February of 2020, the Honorable Supreme Court of India was directed me to file a representation before the National Commission for Scheduled Caste, which is nothing but the respondent number 4, my lord. Then after the Honorable Supreme Court also ordered the NCSA, if a representation has been filed within the stipulated time, my lord, the NCSA will look into this matter and will submit a report to the concerned authority, my lord. That has been placed at page number 289, my lord. I filed my representation, my lord. Then after on 12th March of 2020, they wrote a letter to the respondent number 6 to forward a proposal for exclusion of 4 non-scheduled caste, my lord. From that day, my lord, the NCSE is not responding to this Supreme Court order. The respondent number 6 has sent a wrong report to the NCSE, my lord.
Respondent number 8 ಅಂತ ಹೇಳ.
We'll consider on 8th of August.
Okay, ma'am.
With my lord's kind permission, may I make one mention? Serial number 43, which is a PIL, and I am appearing as party in person. Now they have notified for counseling yesterday.
What?
For counseling for engineering,
Take
architecture
up.
and other courses. Therefore, there is some urgency. They had said on 24th in a different case that under 10 days they will not be notifying. But yesterday they have notified Thursday. And 30th is the last date for option entry. Therefore, in this matter, my lord, there is urgency. It is listed today at serial number 43.
We'll take up in this second.
I'll come in the afternoon. Please. I just wanted to mention because of the urgency.
What is that?
Oblige.
My lord, I'm a party in person. My matter is appearing at serial number 36 today, my lord. I seek some time to give my counter. I'm a respondent.
Take your own date.
Yes, my lord. Sometime after the 15th of August, my lord.
serial number 27.
22nd August.
Your lordship, there's an urgency in this matter, the BBMP's appeal, your lordship.
Right.
In the matter that this lady had mentioned.
Yeah.
This is the BBMP's appeal. She's the respondent. In that matter, your lordship, we've come out against an impugned order of the honorable single judge, wherein action is being taken as against certain officials in the BBMP. And your lordship, they are facing the wrath, and your lordship, is an order of the commissioner. But there are certain officials against which directions have been passed. And that is why the urgency for us, your lordship.
My lord, in fact, I have been ordered to get almost about 50-60 lakhs from the BBMP. I am the loser when I'm taking an extension, actually.
Your lordship, it is our writ appeal and
It is
BBMP
me who have been
employees.
given a lot of, because my dwelling.
No, this is deliberate to
13,
take time in
13.
our
No, my
appeal
lord,
matter.
I can give today, my lord, I'm a tax officer. I'm a
On
review
that day will
meeting
take
is-
up.
Please, your lordship.
On that day will take up.
Your lordship, a short date, your lordship request, because the officials are affected by it, your lordship.
My lord, they have filed an appeal. How can the officials be affected when their stay application also pending before this honorable?
Stay is
court?
pending.
It's me who is.
So how
affected.
they are affected?
Your lordship, they have started initiating action as per the directions of this honorable court, and they have asked them to report back to the learned single judge. If it was even a disposed of matter, we would not have a problem, your lordship. They have asked them to even report to the honorable single judge.
It is pending.
Please, your lordship. That is our
When it is
difficulty.
coming up?
Your lordship, it's the date I'm not too certain, your lordship.
Let it be then.
Any
Titular
short date.
13th of
Please, please.
No, your lordship,
August.
kindly, my serial number 34.
13th of August.
after recess.
13th of August, madam. 13th. So how many years did he?
This one's number 44 for withdrawal. Swati Ashok.
Your Lordship, I filed the memo for.
And two.
Memo dated 16/2/24. Figures on the record. By which the complainant has sought permission to withdraw the contempt petition. Full stop. Accordingly, learned advocate Ms. So and so appearing for the applicant is permitted to withdraw the petition. It is clarified that any future development shall give rise to fresh cause of action in accordance with law. Contempt petition is accordingly disposed of the withdrawal.
Number 45. Avinash BC.
As per the memo of withdrawal figuring on record, it is stated that the matter is settled by the parties outside the court. In view of the above, learned advocate for the applicant, Mr. So and so, Ms. So and so, 6% to withdraw the contempt petition. Dispose of as withdrawn.
Number 46.
Please. Please, my lord.
Umesh Murthy Jain.
Memo for withdrawal with liberty to file a fresh contempt petition, my lord. Because I need to produce some documents to place on record, my lord. That's why liberty is seeking.
The memo dated 29/5/24 is filed, stating that certain correspondent is left out from being placed on record in the present contempt petition. In that view, learned advocate for the petitioner seeks permission to withdraw the contempt application, further seeking liberty to file fresh one. Full stop. This contempt petition is permitted to be withdrawn and disposed of accordingly. Is the liberty reserved for the applicant to file a fresh contempt petition, removing the deficiencies.
Number 47. Mr. Sharath S. Gowda.
For the complainants, my lord. We have filed memo for withdrawal, ma'am.
Memo of withdrawal dated 5/7/24 reads as under. Quote the memo. In that view, the contempt petition is disposable withdrawn.
Yes, number 48, BC Venkatesh.
But I filed a memo, my lord, seeking withdrawal of the petition as not pressed.
In view of the memo dated 25/7/24, seeking permission to withdraw the present contempt petition. The contempt petition is disposed of as withdrawn.
Much.
Number 49,
Appearing for the petitioner, my lord. I filed a memo for withdrawal on 7/7/2024. The petition may be dismissed as not pressed, my lord.
Also for withdrawal. By filing memo dated 8/7/24, it is stated that the prayer in the petition has become infectious, therefore petition may be permitted to withdraw. Permission is granted, petition is dismissed as withdrawn.
Much obliged, deeply obliged.
yes, number 50. Patil Jaya.
For the appellant, my lords, he filed a memo for withdrawal.
This appeal was an interim order.
Yes, my lord.
Memo for withdrawal is filed. Memo for withdrawal dated 9/2/24 is filed by learned advocate Mr. J. Patil for the appellant. Paragraph. The memo reads as under paragraph. In view of what is stated in the memo, the appeal does not survive and is disposed of accordingly.
Much of.
As withdrawn. Disposed of accordingly as withdrawn.
Yes, number 51, Mr. Vasant Kumar HT.
The order has been complied with. The order has been complied with.
Yes, my lord.
Learned advocates parties
I may be
jointly
permitted to
stated
pass
that the
on.
order under contempt is complied with. In that view, the present contempt proceeding does not survive. The petition is disposed of as not surviving.
I'm placing the endorsement on record. Beg your pardon, my lord.
Placing endorsement dated 14/9/23.
I beg your pardon, my lord, I could not produce the translated.
Copy of which is given to learned advocate for the complainant, then both jointly state that.
Wait. This is number 52, Mr. SB Mukana.
Okay, for complaint in this matter. I file a rejoinder in this matter, my lord. Kindly grant 1 week time.
Permit them to.
My lord, in the affidavit, they have stated that, my lord, the board of meeting held on, placed the matter before the board, my lord. My lord, the board meeting held on 5/7/24.
So withdrawals.
My lord, filed a complaints affidavit, my lord, whereas the learned single judge passed an order to consider the complaint representation. So in view of that, the respondent has issued a letter.
So what
Thereby
happened to
it-
this direction? Not complied with?
No, it has been complied, my lord, but
Kindly grant.
But
there is a small delay is there, my lord. It has not been complied within the stipulated date. For that, I have explained that in the affidavit.
Kindly grant 1 week time, my lord. I file a rejoinder, my lord. They have not fully complied, my lord, for that reason.
It's only order of
endorsement is made 6/7/24.
Yes, yeah, issued the endorsement. That is on 6/7/2024 at annexure R1. He clearly,
Representations are disposed of what?
has been clearly stated in the letter, my lord. The matter will be placed before the Board of Management. Then we take a decision whether the complainant is entitled for the pensionary benefits or not.
You neither rejected nor grant.
My lord.
You neither rejected nor grant.
No, my, yes, my lord. The direction is to consider his representation, my lord. So in view of that, we have issued a letter to him, to the complainant, stating that the Board of Management will take a decision with regard to his claim. My lord. No specific direction to pay any benefits and all, my lord, to consider his representation. That is what we have issued a letter to the complainant. He is entitled, my lord, the Board of Management takes a decision to pay me a pension.
We'll say that
we'll
Board
pay.
of Management shall take this within 3 months.
No, my lord, already Board of Management has taken a decision, my lord, for consideration of the grievance of the complaint, my lord. But they have filed a false affidavit, my lord, they will consider place the matter before the board, my lord. For that reason, my lord, I applied some documents.
Board has already taken decision.
Yes, my lord. For that reason, my lord, I applied some documents, my lord.
Learned advocate. Who are you?
I'm for the respondent, my lord. Director of the Multimedia Institute, my lord, belongs to the University of Mysore. Lord, direction issued by the learned single judge, my lord. That is at the operative portion, my lord. Only to consider this representation, my lord. That is what you issued an endorsement stating that we will consider the representation and the same will be placed before the Board of Management, my lord. Based on the endorsement, my lord.
Learn. Petitioner had approached learned single judge by filing petition seeking grant of pension and other retirement benefits in accordance with the 7th Pay Commission. while disposing of the petition, learned single judge directed the authorities to consider the representations of the petition within stipulated time. It is the aforesaid order and the direction which is brought under the contempt jurisdiction of this court. In response to the notice, compliance affidavit came to been filed by the director of education, filed by one Sapna, daughter of late Srinivasa, the director of Educational Multimedia Research Center, University of Mysore, in which the deponent has produced endorsement dated 6/7/24. On the basis of the said endorsement, it was claimed and thought to be submitted by learned advocate Mr. So and so for the respondent, that the directions are complied with. Full stop. When attentively considered, the endorsement makes following observations. And this, that apart, must say, yeah, full stop. Juxtaposed with the above observations, the director, the author of the order, proceeds to observe thus, then second, in view of the foregoing. It appears from the above contents that once the decision was already taken in favor of the petitioner declaring his entitlement for fixation of pay and consequential benefits. Subsequently, the director has changed his stance to take a view that he said decision was not said decision of fixation of pay and holding the petitioner entitled to such pay and regularization was not justified. Full stop. The director shall explain the discrepancy by filing an appropriate affidavit. It is also open to the complainant to file its own affidavit, meeting with the in furtherance of his case. Go to 20th August.
Much.
You explain what we are doing.
My lord.
On one hand, you are saying that he is entitled to. Now by passing
No, my
this,
lord,
you are withdrawing, you are harassing him, evidently.
No, my lord, it is the board has to take a decision.
What board? It is already taken. Now
No,
you
my
are
lord,
changing
no,
your.
board has not taken any decision, my lord. Yet to take this.
Whatever you explain.
Much.
You are saying that board has taken this.
Yes, ma'am. On
So you
5/7.
place on record.
Yes, ma'am.
Much.
December 53. Sumana Bali.
Tender. Sorry, sir.
Lordship, I appear for the appellant lordship. Can I ask for a short accommodation, lordship? I have some personal inconvenience.
Personal income.
Last occasion, she said transaction copy to be given.
Yes, some personal.
Difficulties, my lord, every time, my lord, I am not objecting. Every time, one or other, my lord, it's like,
Lordship, I
because
am suffering from
I know-
viral arthritis, lordship. I am unable to stand
I
stand
know,
for a
I know
long
objection,
time.
I know objection.
When do you want?
2 weeks, lordship.
2 weeks will be
Next week, lordship.
6th of August. 6th of August.
7th, lordship.
7th of August. Then make it a point that on that day you proceed.
At 2:37, my lord.
Midday.
Great. The translated copy she has to give, but I have translated it, but on that day,
What is that?
It is ready. I
Last occasion, not one Kannada document is given by the appellant. She has not given translation. She said she would give translation today.
It is
In
ready.
the
I
meanwhile, I have
will
translated that document.
Yeah.
Submitted on the day of the hearing. Great.
Number 54. The part.
Yeah. Yeah.
May I please, Lord? Lord's, this writ appeal, Lord's, arises from Lord's learned single judge's order, where Lord's we had approached under 226, contending that the jurisdiction of ED's Bangalore zonal office has to be determined with reference to the ingredients of the offense of money laundering. If any of those ingredients, which Milords have been defined under section 3, if any of those ingredients have a locus in the state of Karnataka, only then Milords the Bangalore zonal office of ED can proceed against them. The petitioners, Milords, are husband and wife, who were Milords named in an FIR lodged in 2018 by a person who, by his own averments in the FIR, says that we were very good friends. In fact, para 1 to 16 is only that how close we were at one point in time. And then Milords,
Not mine. Not mine. आपकी है. आपकी है. किसने की है? आपने की है. ठीक है, रखो.
may I proceed, Milords?
Yes.
Please, Milords. So, Milords, we had, Milords, contended before the learned single judge in a writ petition that since none of the process or activities which Milords are specified under Section 3 of the PMLA Act have occurred in the state of Karnataka, the Directorate of, of Enforcement, Bangalore Zonal Office, could not proceed against me, regardless of Millards, where the FIR was. The reason being, Millards, that the offense of money laundering has been held by the Honorable Apex Court in Vijay Madan Lal Chaudhary and Millards, the judgments that have followed Vijay Madan Lal Chaudhary, as a standalone independent offense which has nothing to do with the scheduled offense. The FIR is with respect to the scheduled offense. And I must mention here, because the scheduled offense here is only of cheating. Cheating the complainant, who Millards, according to the allegations in the FIR, which is also on record, was a very close friend of mine. We were like families. He trusted me so much that I introduced certain people to him as builders operating in the state of Maharashtra, Mumbai and Thane to be specific. He trusted me so much that on my recommendation, he started investing in their projects. Not one investment, Millards, some 70, 80 investment, Millards, over a period of 2 years. The total amount being 550 CR. Out of this, Millards, around 1/3 has been returned to him when things were good.
Which will be relevant Section 3.
Section 3, Millards. Section 3, Millards. We'll start with Section 3, Millards. There are some other provisions, Millards, to show that prevention of money laundering actually, Millards, adheres to the territoriality principle, which the learned single judge, Millards, is not even considered. May I read 3, Millards? Offense of money laundering. Whosoever, directly or indirectly, attempts to indulge or knowingly assists or knowingly is a party or is actually involved in any process or activity, Lordship, mark that, connected proceeds to the proceeds of crime, including its concealment, possession, acquisition, or use, and projecting or claiming it as untainted property, shall be guilty of the offense of money laundering. The explanation, Millards. For the removal of doubts, it is hereby clarified that a person shall be guilty of offense of money laundering if such person is found to have directly or indirectly attempted to indulge or knowingly assisted or knowingly is a party or is actually involved in one or more of the following processes or activities connected with proceeds of crime, namely, same, Millards, concealment, possession, acquisition, or use, or projecting as untainted property, or claiming as untainted property in any manner whatsoever. The process or activity connected with the proceeds of crime is a continuing activity and continues till such time a person is directly or indirectly enjoying the proceeds of crime by its concealment or possession or acquisition or use or projecting it as untainted property or claiming it as untainted property in any manner whatsoever. Section 4 is the punishment, Millards, minimum 3 years, maximum 7. In certain circumstances, it can also extend up to 10 years. So, Millards, the processes and activities have been named. The money, the proceeds of crime, his, Millards, here the amount which has been cheated. Out of 550, 150 has gone back, Millards, so it's about 340, 350 crores. As per, Millards, the allegations in the FIR, taking them as it is. Not adding anything to them, not taking away anything from those allegations. So, Millards, some process or activity with respect to that cheated amount should have occurred in the state of Karnataka. And those activities, Millards, as Millards, Lordship has already noted, Millards, the concealment, possession, acquisition, use, etc. The learned single judge, Millards, totally disregards this statutory scheme. Section 3 is quoted in the impugned order. However, Millards, a submission made by the learned counsel for ED before the learned single judge.
The offense is registered at more than one place.
The offense is registered at Hubli, but there were 8 FIRs. 9 rather, 7 have been quashed by this honorable court,
Seven have been,
which have been quashed.
then if it is a Hubli, then this naturally this court will have the jurisdiction.
This court, my lords, will have jurisdiction with respect to the FIR. I am saying money laundering has nothing to do with the scheduled offense. This is what Vijay Madan Lal Chaudhary says. It's a standalone independent offense. Therefore, my lords, if I have bail in the FIR offense, I still have to get a new bail for money laundering and under the more stringent section 45. Let's have section 45 also. I cannot take advantage of that bail. There is a special, my lords, trial mechanism. There are special courts. My lord may have section 45 as well. Offenses to be cognizable and non-bailable. Notwithstanding anything contained in the Code of Criminal Procedure, 1973, no person accused of an offense under this act shall be released on bail or on his own bond unless the public prosecutor has been given an opportunity to oppose the application for such release, and where the public prosecutor opposes the application, the court is satisfied that there are reasonable grounds for believing that he is not guilty of such offense and that he is not likely to commit any offense while on bail, provided that a person who's under the age of 16 years or is a woman or is some concession for people below 16 and women. So, this is a special bail mechanism. I may be on bail, and this is what happened with me. I was on bail. But here, once 4.5 years after the FIR, an ECIR is registered by the Bangalore Zonal Office of the ED. I again have to take bail. My wife has to again take bail. Notice comes to my son also, who is not even named in the FIR. He also had to take bail. So today, we all three are on bail. But these are separate bails. These are from the Special Court PMLA Act. The bail which we had were, my lords, from the Sessions Court, Hubli. Or learned JMFC Court, I'm sorry. So, my lords, the statutory scheme of the PMLA Act, as interpreted by the Honorable Apex Court, holds 3 things. It's a standalone offense. It has nothing to do with the scheduled offense. And it has a special, my lords, mechanism for investigation as well as trial.
So you are trying to segregate the ECIR from FIR.
My lords, there is no, I won't use the word segregation. I am saying, my lords, the offense of money laundering is with respect to the proceeds of crime, the property. The idea is to ensure that this is secured. Under the IPC, my lords, the idea is to punish the offender or the principal idea. Here, my lords, therefore, the ED also has the powers to provisionally attach properties, which they have done in my case, which are also again all in Maharashtra, which I have filed, my lords.
But what FIR is filed at Hubli?
I'm sorry, my lords.
What FIR is filed at Hubli?
Because the FIR filed in Hubli is crime number 23 of 2018, which was, my lords, registered at Ashok Nagar police station. Similarly, 7 more FIRs were lodged, identically worded, because there were about 8 builders. So what, my lords, the complainant did was that in respect of all of them, he filed separate this thing. 7 of those, my lords, have been quashed, my lords, by your lordship's judgment of 21st July 2022, which has attained finality. After that, my lords, there was an earlier FIR of 2017 where I was not even named, because that time the things were good between me and the complainant. Subsequently, my lords, that is crime number 48 of 2017. These are, my lords, of 18. There also, my lords, notices were issued to me. I had to take bail there. And there also, my lords, I have an interim order from the Dharwad court in my favor. So, my lords, my grievance, my lords, is that the learned single judge has, my lords, just confined his scope of inquiry to one thing: the place of registration of FIR, which in my respectful submission, my lords, is incorrect. It, my lords, is against the ratio of Vijay Madan Lal Chaudhary, saying that this is a separate offense. It's a standalone offense. It is independent. In fact, my lords, one expression, and I'll read those paragraphs. It has nothing to do with the scheduled offense.
Nothing to do with?
With the scheduled offense. Where, my lords, in my respectful submission, my lords, the learned single judge has heard there's a submission made by Milos the ED, which is recorded in the impugned order, which Milos is contrary to Vijay Madan Lal Chaudhary. May I read, Milos? Your Lordship need not refer to it. It's a very short submission, which gets accepted as it is in toto. Para 6, Milos, when they are opposing my writ petition. On the other hand, the learned counsel for the ED would refute the submission. My Lord has para 6, Milos. Where may I read, Milos? Page 42. On the other hand, the learned counsel for the ED would refute the submission to contend that the ECIR, which is Milos, the report which they filed, enforcement case investigation report, cannot be registered until FIR is registered under the scheduled offense or predicate offense. Without that, there cannot be a proceeding under the PMLA Act. Admittedly, the crime is registered and charge sheet is filed in the jurisdiction court at Hubli. Therefore, the zonal office Bangalore alone is competent to inquire into that. Now, Milos, may I just pause here for a minute? I will, Milos, demonstrate that their own submission that they can initiate proceedings under the PMLA Act only if there is an FIR already registered is directly contrary to Milos para 290 of Vijay Madan Lal Chaudhary. Vijay Madan Lal Chaudhary, Milos, I had handed over, Milos. There must be two spirals, Milos. 290, 290 para number, right? Synopsis. My Lord has it. Milos, the question that was raised by the petitioners before the Supreme Court was that they are taking action even without FIR being registered and everything. So this is something which Milos, the Supreme Court upholds. 290 may I read, Milos. As a matter of fact, prior to amendment of 2015, the first proviso acted as an impediment for taking such urgent measures even by the authorized officer, who is no less than the rank of the deputy director. We must hasten to add that a nuanced distinction must be kept in mind, that to initiate prosecution for offense under Section 3 of the Act, registration of scheduled offense is a prerequisite for prosecution, Milos. But for initiating action of provisional attachment under Section 5, there need not be a pre-registered criminal case in connection with the scheduled offense. And ED is making a Milos submission about their own powers, entirely contrary to this, and which gets accepted by the learned single judge. May I read further? This is because the machinery provisions cannot be construed in a manner which would eventually frustrate the proceedings under the 2002 Act. Such dispensation alone can secure the proceeds of crime, including prevent and regulate the commission of the offense of money laundering. The authorized officer would thus be expected to, and also in a given case justified in acting with utmost speed to ensure that the proceeds of crime or property is available for being proceeded with appropriately under the 2002 Act, so as not to frustrate any proceedings envisaged by the 2002 Act. In case the scheduled offense is not already registered by the jurisdictional police or complaint filed before the magistrate, it is open to the authorized officer to still proceed under Section 5 of the 2002 Act, while contemporaneously sending information to the jurisdictional police under Section 66, subsection 2 of the 2002 Act for registering an FIR in respect of cognizable offense or report regarding non-cognizable offense. And if the jurisdictional police fails to respond appropriately to such information, the authorized officer under the 2002 Act can take recourse to appropriate remedies, etc., etc. And what do they say, Milods? ECIR cannot even be registered until an FIR is registered. And this is, Milods, what the learned single judge upholds. Lordship may have kindly, page 46. Page 46 of the appeal, Milods. I'm reading from the impugned order, the conclusion of the learned single judge.
Page 40.
Please, Milods. May I read from 44, Milods? Because there, Milods, it also records the submission. This was the only issue, Milods, that the lack of territorial jurisdiction. As observed herein above, Para 9. Now is the analysis, Milos, and then the conclusion. As observed here and above, the contention of the learned counsel for the petitioners is that the Bangalore zonal office, which had registered the crime and now wanting to issue summons, has no jurisdiction to initiate proceedings. I'm sorry. Continue, Milos. Has no jurisdiction to initiate proceedings at Bangalore. The plea of want of jurisdiction is raised on the ground that none of the transactions have happened in Bangalore. And in terms of Section 3 of the Act, it is only the office within whose jurisdiction the transactions have happened would get power to initiate proceedings and issue summons in furtherance of registration of such crime. Since emphasis is placed upon the provisions of the Act to contend that the ED had no jurisdiction, it is germane to notice the provisions of the Act themselves. Section 2(1)(p) of the Act defines what is money laundering. Money laundering in terms of Section 2(1)(p) is as obtaining under Section 3. Section 3 reads as follows. Because I have read this, may I skip this part, Milos? Below the definition of money laundering, below Section 3, Milos. Chapter 2 begins with Section 3, which deals with money laundering. Whosoever directly or indirectly attempts to indulge or is actually involved in any process or activity connected with the proceeds of crime, including its concealment, possession, acquisition, or use, and projecting or claiming it as tainted property, would be guilty of the offense of money laundering. Therefore, the offense of money laundering would be against any person who is involved in any process or activity connected with the proceeds of crime. The soul of crime is proceeds of crime. Milos, till here I have no objection. Now, Milos, kindly see, Milos. The proceeds of crime cannot spring from thin air. The proceeds of crime is to be based on registration of a crime. Factually incorrect. Therefore, the offense of money laundering, though is independent and standalone offense, cannot be initiated without the foundation of registration of a crime, and it is the proceeds of crime. This is, Milos, as I've read, Milos, contrary to para 290 of Vijay Madan Lal, as well as other paragraphs where, Milos, the same ratio has been repeated by the Honorable Apex Court, which I will, Milos, read. Milos,
this registration of crime is under which provision?
I'm sorry, Milos.
The registration of crime which is spoken of in paragraph
420, Milos. 420 IPC cheating.
Then it is the foundation is FIR or not?
Milos, the foundation is for the scheduled offense. This is precisely what I'm saying. The foundation for money laundering is the process or activity which has not been disputed by the ED also that no.
Originated where?
Milos, therefore, Milos, the issue of money proceeds of crime originating has to be linked to where the amount has been derived from. If it has been derived from or obtained or concealed or used or possessed or acquired in Karnataka,
So
I have no case.
That link will be established at what stage?
Not, Milos, that link, if Milos, because this is a case, Milos, where there is material on record, and this is a case where only bank transactions are involved. That is something, Milos, which I will show from page 814. From the charge sheets that have been filed, each and every transaction has originated from Maharashtra and gone to a recipient in Maharashtra. It is not their case. All the properties that have been purchased by these builders and the accused and the complainant are in Maharashtra. Milos, the FIR, Your Lordship, I will read some paragraphs from there as well. It's at page 102, Milos.
Single judge based the entire reasoning on that FIR.
Only on that FIR.
Initiation by filing FIR at Hubli. So where is that FIR?
Page 102, Milos. Annexure A. And Your Lordship will see all the accused at page 103 onwards are also residents of Maharashtra.
Page 108. 108.
Please, my lord. Lordship,
Type copy is same.
type copy is there. Your lordship is right. I'm sorry, this is a better copy. Sorry, this is in English, right. Lordship, may I have page 110? This is, my lords, where the list of all the accused persons is. I am accused number 1. Even though no money has come to me from the complainant, I have only introduced these builders. Accused number 2 is my wife, again a resident of Maharashtra. 3, 4, 5, 6. They are also not builders. They're all middlemen, so to speak. All residents of Maharashtra. Someone is Raigad, someone is Sangli, someone, my lords, is Kolhapur. 7, 8 again, my lords. Not one accused also here. Even if, my lords, right up to, my lords, accused number 14. Now, my lords, while we are at the FIR, may I, my lords, invite your lordship's attention to lordship, may I have para 16 of the FIR at 123 minutes. The complainant himself is a resident of Maharashtra. He only has businesses in Karnataka. It's definitely more convenient for him to harass us here. Lordship, may I have para 16 of the FIR, which will also show, my lords, the place where, my lords, real estate development had to take place.
Paragraph.
Para 16 at 123, my lord. The complaint, right? This is complainant's stated case. During the year 2014, when I was in Hubli, Mr. Sheetal Kumar Sudhakar Manere, who's applicant number 1, met me at the aforesaid address and informed that I should make investments in the real estate, where I would reap maximum benefits and profits. He represented that he has several associates who are builders at Mumbai and Thane. Lordship, may mark that, where there is great demand for real estate development, and also a few of his friends have prime lands there. He insisted that I should make investments. When I informed that I do not have much time to devote for the same, Mr. Sheetal Sudhakar Manere represented that he would assist me, ensuring that my investments would be safe and garnering good profits. He also informed that he has a team who would help and assist in the business transactions. 17. I considered the proposal made by Mr. Sheetal Kumar. Thereafter, he introduced the above said Mr. So-and-so, stating that they are into real estate and also own certain properties for development. Later, he introduced Mr. So-and-so, stating that he's politically well connected and he would help me in government clearance for the project, ensuring that the construction of the same would be completed faster, yielding good results. Thereafter, he introduced one so-and-so, stating that he's a friend who assists him for the clearance, etc. So, my lords, this is how. Lordship, may I have para 20 now? There is nothing material which I'm missing out. Lordship may take it from me, because it's a complaint, my lords, which runs into more than 60 pages. So therefore, kindly have para 20, where he says that the initial investments yielded very good results. As per the advice and recommendations of Mr. Sheetal Kumar and Mrs. Jyoti Sheetal Kumar, I agreed to make investments in few of the projects recommended by Mr. Sheetal Kumar. Initially, at the request and recommendation of Mr. Sheetal Kumar, I invested a sum of rupees 4 crore each in Messrs. So-and-so, all represented by his director, Mr. Abhishek Ramesh Vyas. Mr. Sheetal Kumar had represented that these amounts would be made use of by these entities for real estate development, and since the value of the said developed property would go up, I could benefit from the same, either by selling it to third parties or by the developer buying the development or construction from me. As per their representations, all the above 3 entities made payment of a sum of rupees 5.9 crores each in July, August to me. This returns enhanced my belief on Mr. Sheetal Kumar and others other above said persons, making me to believe that the transaction carried out by them are genuine. So he invests 5 crores, 5 crores, 5 crores with 3 entities, gets back 5.9, 5.9, 5.9. So he's satisfied. Then he makes further investments, para 21. Thereafter, Mr. Sheetal Kumar introduced Mr. Abhishek Suresh Asrani. He's one of the builders, Milos, stating that he's the proprietor of Mrs. Chanchal Das, which is into real estate business. He also introduced Mr. Mahesh Oza, another builder, proprietor of Mrs. Karan Group Builders and Developers, Mr. Vivek Dhamanse, director of Varad Infra Projects, Mr. Abhishek Asrani, Mr. Mahesh Oza, and Mr. Vivek held out that they are putting up construction at prime localities, and in the event of me investing in their projects, the value of the same would go up after the real estate development. Accordingly, I made certain investments with them, and in turn, they returned my investments with profits. Till the time money is coming, it is all fine. Later, if there is some issue, it becomes a criminal case. But that, Milos, is an issue which I need to, Milos, argue in quashing of FIR, which is also pending. They also made payments of various sums of money in the end of year 2014 and beginning of 2015 as a return on investments stroke capital to me. This is important, Milos. During all this time, Mr. Sheetal Kumar Sudhakar Manere categorically represented that the real estate business in Mumbai and Thane was booming, and that is the reason for the high rate of returns. He further represented that these areas would continue to boom and real estate business would flourish. Mr. Sheetal Kumar Sudhakar Manere and his associates having made available return on investments to me from time to time, and they having complied with their obligations, as also adhered to their representation, I was very much impressed with them and by their actions, due to which my trust in them grew. Para 22, Milos. Subsequently thereto, from the middle of 2015, Mr. Sheetal Kumar Sudhakar Manere approached me and stated that small investments would yield small returns, whereas big investments would earn big returns, and further represented that I can own major areas of buildings being constructed and earn big profits. Induced by these representations and believing his statements to be true, and as I had implicit trust in Mr. Sheetal Kumar Sudhakar Manere on account of his manner and methodology, as well as that of his wife, Mrs. Jyoti, I started making payments of higher amounts of money in terms of their requests and recommendations. I have made the following payments. These, Milos, are the payments which have been made and which, Milos, constitute proceeds of crime. First, Milos, column is entity, amount released by the complainant, and date. And then, Milos, he has mapped all the payments that he has made, the complainant has made, to builders allegedly introduced by my clients. And Milos, he doesn't know anything, even though, Milos, he's a businessman having several business interests. He invests 550 crores only on my trust because I had introduced these builders, while also admitting that he's got good returns. Lordship may just have para, just glance over this, Milos. The first column are, Milos, the people, the builders to whom he has made payments, then the amounts, and then, Milos, so this runs into, Milos, 4-5 pages. At page 130, Milos, I would invite your Lordship's attention, because he's the builder, Milos, Messrs. Chanchal Das Investment Group. My Lord has that, 130. He has been paid, Milos, 102 crores. And then he has another firm, Chanchal Das and Sons, that has also been paid, Milos, some 3-4 crores. So a total of 106 crores has been paid. Now, Milos, in this complaint, the complainant himself admits that there has been return by this Messrs. Chanchal Das, whose proprietor is Abhishek Asrani, of about 1/3 of this amount, Milos, about 30 odd crores, which is at 158. Para 58, Milos, I'll just read. Messrs. Chanchal Das and Sons has repaid a sum of rupees 29.8 crores to me out of the total investment of rupees 106 crores made by me. Milos, while we are still in the facts, may I, Milos, urge your Lordship to kindly take volume 3 of my writ appeal, because this will show that the charge sheets themselves have mapped all the payments, have annexed all the bank documents, the bank statements. Page 813 first. 813 minutes. And these are not disputed by the minutes before the learned single judge. The learned single judge also does not say that any transaction or anything happened in Karnataka, except the registration of FIR, which according to us is, Milords, not the germane consideration. My lord has page 813. Because right at the top, Milords, is the heading. Payments made to Messrs. Chanchal Das, Abhishek Asrani, accused number 1, on various dates by Messrs. Sanjay Godawat. These are the dates, Milords. Sanjay Godawat, Milords, is the complainant. Serial number, then there is date, then there is amount as per the FIR. Milords, these are those very entries which are mentioned in the complaint, where, Milords, I had shown from those charts that he has given details of those 550 odd crores, out of which 1/3 has already been returned to him. But kindly see, Milords, the reason why we have mapped this from the charge sheet is to show, Milords, how these transactions have happened and the bank branches that were involved. If there is even one bank branch in Karnataka, Milords, the writ appeal should be dismissed. Because the process or activity of concealment or acquisition or transfer will have a locus in Karnataka in that case. My lords may have complainant's bank account and page number in the charge sheet. Because what I have put in bold is the bank branch, HDFC Jaisingpur, Maharashtra. And then, Milords, the builder's bank account and page number in charge sheet. This is Kotak Bank, Mumbai, Chembur. Not one bank transaction in Karnataka, insofar as proceeds of crime going from the complainant to builders is concerned. There can be no other proceeds of crime. It is his contention that this is what I have been cheated of. So we've mapped all this. And these are all, Milords, if your lordship sees, Milords, 2 of his banks are involved, HDFC Jaisingpur, Maharashtra, and HDFC Sangli, Maharashtra. Lordship may kindly, Milords, also have page 815. This is, Milords, here from the charge sheet only. And the charge sheet itself says at page 816. 815 is the charge sheet. And 816, Milords, this is the document forming part of the charge sheet. Once again, first column is date. Second is payment made by, complainant's name is there, Milords. The copy may not be very clear, Milords, because that's how we got it in the charge sheet also. Then, Milords, there is an amount. Then it says our bank. Our bank means, Milords, the complainant's bank. Presumably, this statement was given by the complainant to CID, and they just made it a part of the charge sheet. Then, Milords, the branch is again Jaisingpur, Sangli, Jaisingpur, Sangli. These are all Maharashtra branches of HDFC Bank. Then, Milords, is the account number of the complainant. And then the party bank. Party is, Milords, the builder who has received payment from Sanjay Godawat. In this case, Milords, if your lordship sees at the heading, is one person called, firm called NK Enterprises, whose proprietor is one Nilesh Sable, who's also an accused. His bank is, Milords, Punjab National Bank, again in Maharashtra, Nerul West, Nerul West, Nerul West. And, Milords, the mode of payment is RTGS. Similarly, for all the other builders, Milords, we have done it. And from the charge sheet, annexing parts of the charge sheet. No dispute, Milords, not disputed by them. One more document I would like your, Milords, invite your lordship's attention is at page 826. This is, Milords, again from the charge sheet, the list of properties that have been purchased by the accused builders and the complainant in joint names. This is an interesting case, Milords, where the person who is being cheated or the person who is cheating is buying property in joint names with him. So here the accused builder and the cheated person are joint owners of several properties. And they're all in Maharashtra. That is my limited purpose. Land bearing city survey number, village Mahul, Taluka Kurla, Mumbai, so and so, Pushpak Nagar, Taluk Panvel. These are Milos all with respect to each builder. Milos, I am not a builder. No money has come to me from the complainant. My only role is that I have introduced certain persons as builders, and those builders have given me some amount, whether it's commission or brokerage or whatever. But my accounts are also in Maharashtra. Now, Milos, if some money has come to me from the builders as whatever, facilitation fee, whatever, commission, brokerage, whatever, I am answerable to the builders. Those builders are nowhere saying that because we have given a certain percentage to Mr. Sheetal Kumar, therefore, we are reducing our liability towards the complainant. But Milos, again, I would urge Milos, these are all issues, Milos, perhaps for a 482 quashing petition, Milos, where also we are arguing these points. But the idea here was, Milos, only on territorial. Each and every transaction originates from Maharashtra, where the complainant's accounts are, and Milos terminates in Maharashtra, where builders' bank accounts are. They jointly purchase properties. Each and every property is in Maharashtra. Milos, all these things have been given a total go by the learned single judge. Why? Registration of FIR, and that also, Milos, on a misconstrued principle that without FIR, ED cannot act. So, Milos, now, Milos, if your lordships were to see certain paragraphs, Milos, may I, in this background, just hand over a very brief synopsis, Milos, just to Milos point out where, Milos, in our respectful submission, the learned single judge has heard. I will just give you a copy. And Milos have tried to, because the record is a little voluminous, have tried to, Milos, so that, Milos, we can confine the submissions only to, Milos, what is directly relevant. Because I could have understood if the learned single judge had said that no one process or activity relating to money laundering has a locus in Karnataka. Registration of FIR is totally, Milos, extraneous insofar as the jurisdiction of ED is concerned. Otherwise, Milos, they can do anything. And I will show from the Act, Milos, that their jurisdiction is similar to, Milos, the jurisdiction of the investigating officer under CRPC. Milos, 1 and 2, Milos, is a brief background, and 2 is, Milos, my principal contention. Kindly have para 3 at page 2. The learned single judge has dismissed the writ petition despite the following uncontroverted facts. No process or activity constituting the offense of money laundering occurred in Karnataka. Even the single judge doesn't hold otherwise. The above assertion was substantiated through mapping of all the bank transactions that formed the basis of the predicate offense of cheating and formed part of the FIR. Significantly, the ED did not even dispute the contention that no process or activity had a locus in Karnataka. Now, Milos, ED's contention, Milos, which I have already briefly referred to, is contrary to, Milos, para 290, 311 and 467. ED's contention, Milos, is that ECIR cannot be registered until an FIR is registered under the scheduled offense.
Which paragraph?
Para 4.
To page?
Same, page 2, Milos. Of the synopsis, Milos. Of the synopsis.
No.
Of the synopsis. ED's contention, Milos, is contrary to para 290. That ECIR cannot be registered until a FIR is registered under the scheduled offense. I have read to your lordships, Milos, they can proceed even without the registration of FIR. And that is repeated not only in para 290, which I have already read to your lordships, also under 311 and 467, Roman 18 and A. 467 is of course conclusions, Milo, so there will be some repetition. The learned single judge accepted ED's erroneous contention without giving any reasons therefore. However, the petitioner's plea of want of jurisdiction on the ground that none of the transactions have happened in Bangalore, because my contention was Karnataka, not Bangalore. The single judge records it, was rejected, dehors the ratio of Vijay Madanlal. Now, Milods, because I think there's a problem with the numbering, or should may kindly just make a small correction. This should be my proposition 5, not 4. 4 has got repeated. Money laundering is an independent standalone offense. The impugned order has been passed contrary to the following settled principles. The offense of money laundering has nothing to do with the scheduled offense, and the same has been held by the Honorable Supreme Court to be an independent standalone offense regarding the process or activity connected with the proceeds of crime, which had been derived or obtained as a result of criminal activity relating to or in relation to a scheduled offense. Owing to the distinct character of the offense of money laundering, an accused who may already be on bail in respect of the scheduled offense has to nevertheless again seek bail under the more stringent Section 45 of the PMLA Act. A person who may be charged with money laundering, even if he had nothing to do with the scheduled offense and was neither named in the FIR nor in the charge sheet. So, Milords, like my son, who was neither named in the FIR nor in the charge sheet, but he's an accused before the ED. Now, 2 judgments, Milords. One is Pavna Debur, but before that, Vijay Madanlal, Milords. Just 3 paragraphs I will read, Milords. 3 or 4 paragraphs. Lordship, may kindly have the spiral again, please. Para 269. None of this, Milords, has been gone into by the learned single judge.
269.
Para 269, Milords.
From the bare reading. From the bare language of section.
From the bare language. That's right. May I read this? From the bare language of Section 3 of the 2002 Act, it is amply clear that the offense of money laundering is an independent offense regarding the process or activity connected with the proceeds of crime, which had been derived or obtained as a result of criminal activity relating to or in relation to a scheduled offense. The process or activity can be in any form, be it one of concealment, possession, acquisition, use of proceeds of crime, as much as projecting it as untainted property or claiming it to be so. Thus, involvement in any one of such process or activity connected with the proceeds of crime would constitute the offense of money laundering. This offense otherwise has nothing to do with the criminal activity relating to a scheduled offense, except the proceeds of crime derived or obtained as a result of that crime. But in my case, Milords, the property has also been derived in Maharashtra, the bank transactions. Now, Milords, para 270. I'll read only part of it. Needless to mention that such process or activity can be indulged in only after the property is derived or obtained as a result of criminal activity, a scheduled offense. It would be an offense of money laundering to indulge in or to assist or being party to the process or activity connected with the proceeds of crime. And such process or activity in a given fact situation may be a continuing offense, irrespective of the date and time of commission of the scheduled offense. In other words, the criminal activity may have been committed before the same had been notified as a scheduled offense for the purpose of the 2002 Act. But if a person has indulged in or continues to indulge directly or indirectly in dealing with the proceeds of crime derived or obtained from such criminal activity, even after it has been notified as a scheduled offense, may be liable to be prosecuted for the offense of money laundering under the 2002 Act for continuing to possess or conceal the proceeds of crime or retaining possession thereof, or uses it in trenches until fully exhausted. The offense of money laundering is not dependent on or linked to the date on which the scheduled offense, or if we may say so, the predicate offense has been committed. The relevant date is the date on which the person indulges in the process or activity connected with such proceeds of crime. So those 3 important points in this paragraph. Money laundering is an independent offense regarding the process or activity. Money laundering has nothing to do with the scheduled offense except the proceeds of crime. Money laundering is not dependent or linked to the date on which the scheduled offense is committed. Now, my lords, this has been taken a little further. I'm sorry, my lords. So, my lords, may I continue? So, my lords, here, my lords, if a person has been cheated, the accused, and then, my lords, someone who has nothing to do with the offense of cheating, but helps the accused to, my lords, invest that money somewhere, conceal that money somewhere, he will still be guilty of money laundering, even though he was not party to the offense of cheating. And this is, my lords, what the Honorable Supreme Court in a more recent judgment, just one para from this, my lords. Pavna Dibbu. Para 17, my lords. Where, my lords, para 270 of Vijay Madan Lal Chaudhary is followed, which I just read to your lordships. Coming back to section 3 of the PMLA, on its plain reading, an offense under section 3. I'm so sorry. Para 17. Coming back to section 3 of the PMLA, on its plain reading, an offense under section 3 can be committed after a scheduled offense is committed. For example, let us take the case of a person who is unconnected with the scheduled offense. I'm so sorry, Ms.
Yes.
Please, Ms. Coming back to section 3 of the PMLA, on its plain reading, an offense under section 3 can be committed after a scheduled offense is committed. For example, let us take the case of a person who is unconnected with the scheduled offense, knowingly assists the concealment of the proceeds of crime, or knowingly assists the use of proceeds of crime. In that case, he can be held guilty of committing an offense under section 3 of the PMLA. To give a concrete example, the offenses under section 384 to 389 of the IPC relating to extortion are scheduled offenses included in paragraph 1 of schedule to the PMLA. An accused may commit a crime of extortion covered by section 384 to 389 of IPC and extort money. Subsequently, a person unconnected with the offense of extortion may assist the said accused in the concealment of the proceeds of extortion. In such a case, the person who assists the accused in the scheduled offense for concealing the proceeds of crime of extortion can be guilty of the offense of money laundering. Now, my lords, therefore, it is not necessary that a person against whom the offense under section 3 of the PMLA is alleged must have been shown as the accused in the scheduled offense. What is held in para 270 of the decision of this court in case of Vijay Madan Lal supports the above conclusion. The condition precedent for attracting the offense under section 3 are that there must be a scheduled offense and that there must be proceeds of crime in relation to the scheduled offense as defined in clause U of subsection 1 of section 3 of the PMLA. Now, my lords, just taking this illustration further, suppose, my lords, through extortion, someone gets a ransom. And then, my lords, uses his friends and family in some other part of the country to, my lords, deploy those funds.
Deploy?
My lords, those funds, my lords, which have been extorted, he will do something with them. He will buy real estate, or he will, my lords, buy gold, or he will buy, my lords. So he will, my lords, people who he knows, or, my lords, he will find ways to use those funds. And he uses them in some other part of the country, my lords. Let's say he uses them, my lords, the extortion happened in South, and he uses them in North India, in Delhi, or in, my lords, Gurgaon, or wherever. Now, my lords, there, if the extortion, there, my lords, if the extortion money has been taken in South, then you can say that ED here will have jurisdiction, but not because the offense is committed here or the FIR with respect to extortion is registered here. Because the possession of the proceeds of crime has happened in South, in Karnataka. In my case, Milos, not a single rupee. This man has implicated all of us because of his clout in Karnataka. As per his own admission in the FIR, he has businesses here. None of the accused are residents of Maharashtra, of Karnataka. None of the properties jointly purchased have been acquired and have been purchased in Karnataka. No, not a single rupee has either originated from Karnataka or come back into Karnataka. This is a peculiar case, and it has become peculiar because of Milot's methods adopt these sharp practices by the complainant. Otherwise, usually Milot's, wherever the offense is committed, the proceeds of crime Milot's in most circumstances originate there, or some of those process or activities will have a locus there, whether it be concealment or use or possession or acquisition or whatever. But here, because of this sharp practice which he has deployed, to register an FIR in Hubli, when the projects were had to be set up in Mumbai and Thane. Therefore, Milos, I want to, Milos, take advantage of that, Milos, I say this for want of a better word, and Milos, impugn the territorial jurisdiction of ED Bangalore insofar as money laundering is concerned. Otherwise, it's very simple, Milos. You just say that we have.
You're rising early.
Not difficult. This will take some time. Milos, incidentally, Milos, in fact, Your Lordship may recall Justice Dixit had asked me that is there any precedent? And I said so, Milos, and we
coming from outside?
From Delhi, Milos.
Delhi.
Please, Milos. We'll come again, Milos. But this is an area, Milos, which is, there is actually not much precedent because the facts are peculiar thanks to the complainant. He has chosen Hubli to register an FIR, which had nothing to do with Hubli. Otherwise, in most cases, Milos, it's
Journey of money started from Hubli.
Hubli, and it ended also.
No.
Though it bounced.
Not journey of money.
Journey of money.
No. Not one rupee. Not 1 rupee.
No, it is a matter of investigation.
No, Milos. The investigation, all those entries have been mapped.
Lord, the complainant Godawat issued money from Hubli. That is what he says.
No, I'm so sorry.
The Godawat, the complainant, Sanjay Godawat, he issued the money from Hubli.
That is how it affects.
I have mapped all the transactions below. Let them file an affidavit that which bank account of this thing has the money gone to the.
There is the complaint, Lord, no affidavit is required. But my learned friend complete, Lord,
No, Milos, there has to be. It can't be like, that you just make a statement. You make that good. You have to be neutral.
That will be done. Yeah, you complete.
You make that good. You filed the documents. Where does it say that any money, any of those 500 crores, even 1 crore from that has originated? Then I have no case. And this is not in their case before the single judge also. And therefore the impugned order doesn't say so. Because Milos, if the single judge had said that yes, 1 transaction, 2 transactions out of these 100 have originated from some bank branch in Karnataka, that would have been the end of my case. You have admitted my position.
What is the point of laundering?
No, I don't want to, now your lordships are raising, I don't want to begin now. After my learned friend completes, I've got elaborate submissions to make, I'll take your lordships to that.
When shall we come? Don't take longer time, otherwise we will forget.
No,
No, you will. What about your matter?
I'm sorry, Milos.
The counseling has been notified yesterday. The last date, my lord, is 30th for
30th.
option 9. Therefore, it can taken up on 29. But my humble request, my lord, again and again, it will be
Notify in the board. In the
for
board.
hearing on IML.
Board 2 it will be notified and it will be notified in board 2, which will be taken up first.
Please.
I think so 2nd August, you were in a difficulty last time.
You filed a statement by then?
I wanted second because it was first
No,
time
no,
here again.
no, 2nd August I'm back.
I know. You're not here, bro.
No, 2nd August I'm here.
Oh, 2nd August, so we can have it on 2nd.
That is next Friday.
Second now.
My lord, one submission with regard to the moved matter, that is serial number 43, which your lordship said will be called on the 29th. In that, my lord, the state hasn't filed objections and this matter is of the year 2020. It relates to fixation of fee and
Thank you.
counseling. My lord, in that,
Serial number 34, my lord. Next week, any date may be granted.
Because can it be 9th, Milos? It's a joint request. 2nd would be too short, Milos. It's a
Which date?
9th, Milos. 2 weeks.
That is the week after next. I'm ready.
Next to next Friday. Milos, there's an interim order, Milos, some limited protection you'll ought to
And
grant.
order at the 10.29th interim order granted earlier shall continue to operate till 9th is Saturday,
9th
No,
is
Lord,
Friday.
it's Friday.
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 Week after next.
Milos, can it be at 2:30 if possible, Milos?
On that day we'll see.
Grateful.
Permission. Number 33, my lord, sign for the workman. My friend colleague Subramaniam is here. We may have it, my lord, so lordship may have it on 31st possible. Your lordship's kind permission. Time for workman, only limited point is, my lord, about back wages. He's working and he was taken for duty. 33.
In serial number 33, the interim arrangement has already been made. He has been reinstated and he is being paid salary of rupees 82,000 per month. That is the interim arrangement as well. It has to be heard finally, madam. We are ready. It has to be heard finally.
Only on the point
Whether-
of back wages.
1 second. Whether he is entitled for back wages, whether he is entitled for continuity of service. Consequently, when he has refused to do the work allotted to him, even before this honorable court, he was not prepared to accept alternative job. He was prepared to do only alternative job. This court persisted him to undergo medical examination. So therefore, it has to be heard finally. We are ready.
Whenever you want.
31st, plus.
31st.
31st next
Which is
Wednesday.
that number, serial number?
And he is working now, Major. For the
30
last 10
33.
months, he is working.
33.
All right, whenever you want.
I'm praying, my lord, 31st would it be possible?
At the request of learned counsel for the party, stand out. 30.
My lord, serial number 22, my lord. Arrears of salary not paid, my lord. Pass or matter, my lord. Serial number 22, my lord. Arrears of salary has not been paid by the respondent.
He had a date of choice.
My lord, serial number 34, my lord.